Hello, everyone, and welcome back to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney. We learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney. We learn through the misfortunes of others. As always, we learn through the misfortunes of others. I'm Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. And I am glad that you are here with me today. As always, we are here to talk about the impeachment trial of Ken Paxton, the Texas Attorney General. Ken Paxton was elected to be the Attorney General by 4 million Texans, but has been under investigation for quite some time for various misdeeds or alleged misdeeds, indicted in 2015 in relation to securities frauds in a case that still has yet to go to trial. For the purposes of the impeachment, however, he is being impeached as relates to his official duties as Attorney General, in which he is alleged to have helped a man named Mr. Paul in a way that was improper. He showed benefit to Mr. Paul in a special way, in a way that showed special treatment, corrupted his office in order to benefit this one person, potentially at the expense of other people. Corrupt motive. Corrupt purpose, corrupt intent. This is the idea, that he effectively turned over his office to the control of Mr. Paul, at least in part, of course, and helped Mr. Paul by, for example, among other things, drafting an opinion letter from the Office of the Attorney General to stay off foreclosures because Mr. Paul was undergoing foreclosures, because Mr. Paul is a real estate developer. And so he wrote an opinion letter to try to prevent foreclosures from going forward so that Mr. Paul wouldn't have his properties foreclosed upon. By, for example, interceding in a charity that Mr. Paul had some interest in, and in a way that was not proper, by trying to get directly involved as the Attorney General in some district court case that had no particular importance to Texas to benefit Mr. Paul, by appointing an outside lawyer through an improper mechanism to do an investigation and start issuing subpoenas, also to potentially benefit Mr. Paul. This is the allegation, generally speaking. And then, of course, the cover-up, that he retaliated against the whistleblowers in violation of law, and that he then tried to pay off the whistleblowers using taxpayer money, even though it was representing his own failings rather than the misdeeds of the Texas government. These are the generalized allegations, of course, in a paraphrased kind of way, but you get the gist of what we're talking about. So far, we have heard from 3 different witnesses who worked for the Attorney General's office in fairly high capacity at the Attorney General's office. The upper senior leadership of the Attorney General's office, all of whom are accomplished in their own right by being very high in their respective law school classes, well educated, having experiences including judicial clerkships, being partners at prestigious law firms, and otherwise having experience in various things that, earned them the positions that they had. The testimony from these individuals have so far laid out their observations of Ken Paxton's behavior and their observations, at least in their judgment, of the abnormality of Ken Paxton's behavior vis-a-vis how he would treat other kinds of cases. So that is what they've sort of testified to. It's like, we have experience in the Attorney General's office. We were there in some cases for numerous years. We observed how Ken Paxton normally behaved as it relates to his duties. And being the Attorney General, typically, as you would typically expect, most of those duties are delegated down. He didn't typically get involved in sort of the ordinary and normal and banal. As you sort of would expect, he only got involved in particularly important cases or particularly controversial cases or cases of particular note to Texas, right? Normally speaking, he just doesn't do things personally. That's why he has a staff, like sort of any CEO, if you like, of any entity. But what they say is they observed the Attorney General doing things personally and making directives in a way that was abnormal for him, in a way that seemed to benefit this particular individual, Mr. Paul. So, as I mentioned, that he wanted to get directly involved in being a litigant in a sort of banal, everyday district court case in Travis County, which, as you would expect, is pretty abnormal. The Attorney General doesn't normally get involved in normal, everyday, banal district court cases because they have more important things to do. So it's like, that was weird that they wanted him to meet with this guy, Mr. Paul, at a restaurant to hear him out about why they should intervene in this charity case that there was no particular interest for Texas to get involved in. Texas certainly can get involved in cases involving charities to the extent that they're corrupt. So the idea of them doing that, is not wholly invalid. But in this particular case, as you were evaluating, it didn't make any sense. And he seemed to put undue pressure on them to change their mind, to get them to sign off on contracts that they wouldn't normally sign off on in relation to hiring particular people, in this sort of last minute gun to the head, at least by their characterization, of the Attorney General trying to get them to sign off on an Attorney General's opinion to benefit Mr. Paul by hiring this outside counsel to do the investigations in a way that was improper, and didn't go through the normal processes. The Attorney General is directly doing things personally in a way that sort of violates their own standard policies. And at least in their view, always seems to come back to Mr. Paul. And so that's sort of the gist of the case as it's been presented by these witnesses. The defense team, for their part, has done a very good job, at least in their part, in laying out the idea that these witnesses had an incomplete picture and perhaps were presumptive and didn't recognize the authority of the Attorney General to do things because the internal policies of the office are not law. And so the Attorney General can ignore them and were presumptive as bureaucrats and reached conclusions that were ultimately unwarranted and perhaps didn't give Ken Paxton adequate opportunity to explain himself, and just made what might be, or at least on a superficial level, a reasonable assumption, but without looking into it in sort of depth. So they didn't do a thorough enough investigation. Also, just kind of showing them in many cases to also have done things themselves that are questionable at best. So unclean hands, which, by the way, just incidentally, doesn't of course speak to what Ken Paxton did or did not do. Just for the record, like, these people may or may not be the biggest criminals of all time, but of course that doesn't speak to Ken Paxton. It does, however, speak to their character and at least their credibility, just so that we're properly delineating these things. So even if you assume or reach the conclusion that these people were staging a coup, it doesn't necessarily speak to what Ken Paxton did or did not do. Both things could theoretically be true at the same time, just so that we have our thinking hats on, right? Just because they staged a coup, just because they improperly took his name off the letterhead, just because they interfered with his duties, just because they just because they sent secret, confidential grand jury subpoenas through official email to people unauthorized to receive those subpoenas, and then tried to delete the record of them doing it, which might also be perceived as a cover-up because you're trying to delete the record of your potentially illegal thing. So even if you assume that these people broke the law in these various things. It, of course, ultimately doesn't speak to whether Ken Paxton broke the law. Whether Ken Paxton broke the law speaks to primarily his motivation for doing things. Because, as we sort of discussed before, the same exact activity, the same exact act, can be both legal and illegal, depending, of course, on why you're doing it, particularly if you're a governmental official, right? Governmental officials can do things. They can perform all kinds of actions. But if they're doing it for personal reasons, if they're doing it for reasons not in the benefit of the government, but for their own personal reasons, it becomes a corrupt reason. And that makes it illegal. So you need to understand the reason behind why they did the thing to do it, right? And you can understand this like on Basic Principles 101. Like you can think about this in terms of a political prosecution if you want an example, right? And we've sort of discussed this in sort of some cases, right? So a prosecutor wants to bring charges against a guy, or they're investigating a guy, right? Is the reason that they're doing that investigation because they really believe this guy broke the law, in which case what they're doing is legal? Or is the reason they're doing it because they don't like this guy on a personal level, a political level? They're doing it as retaliation, in which case it's illegal. So, the same thing, the government is doing an investigation, just to pick an example. Or if you like, for example, another example from perhaps the Obama administration with, for example, the IRS tax scandal, right? Where the IRS was denying tax status to various nonprofits or would-be nonprofits that were related to right-wing causes. If the reason that they're doing it is because they're not really real charities and they're fronts, then it's legal. If the reason that they're doing it is because they don't like the message, it's illegal. So the reason that the IRS is doing it, just to pick an example, becomes important. The corrupt purpose, corrupt motive, corrupt intent goes a long way to understanding its criminality. So that's sort of the gist of how we're supposed to assess this. So in a lot of ways, while the defense has done a good job at least laying out and teasing the possibility that these people didn't understand what was going on and teased out the possibility that Ken Paxton was doing things for legitimate reasons, and the defense has so far more teased out the possibility and laid out an insinuation than really provided evidence, which is fine, by the way, because, of course, it's not the defense's turn to present evidence, right? Their job at this point is cross-examination to weaken their case, which they are doing. They are certainly weakening their case and also showing these people to have engaged in improper things, which speaks to their own character. And also, of course, to the extent the Attorney General was aware of those things, would give the Attorney General a lawful basis to fire these people. Again, it goes to legal versus illegal. If the Attorney General fires these people for being whistleblowers, it's illegal. If he fires them because they are trying to stage a coup by, for example, among other things, taking his name off the letterhead, sending emails, including private and confidential grand jury records to people unauthorized to receive them, if that's his reason for firing him, it becomes legal. So why was the Attorney General doing it? What was the Attorney General's knowledge? And what was his motivation? What was his real reason for doing it? Right? And so that's sort of the conclusions we're trying to reach. Of course, it's also worth noting, by the way, that at least in this context, we're also trying to go beyond a reasonable doubt, which is a bit unusual in this kind of analysis, because the kind of questions we're asking are typically like civil questions. Like if you wanted to bring a complaint, typically against an employer, like for example, they fired me because of religion, They fired me because of sex. They fired me because of race. Typically, of course, you're in a civil context, and you're just more likely than not. Right? Is the real reason the employer fired the person because of race, because of sex, because of religion, or is the real reason they did it because of insert whatever legitimate reason here? And then, you would look at the evidence that presents both possibilities, and then you would assess, okay, which is more likely than not. But that's not what we're doing here. We're doing beyond reasonable doubt. Right? So that's a bit unusual. That's a bit unusual that we're trying to reach the beyond a reasonable doubt question. So it isn't a question of which is more likely than not. It is, are we convinced beyond reasonable doubt? Which at this point so far, no, I'm not. But that's okay, because of course the prosecution isn't done yet. They're laying out the groundwork. And they've presented evidence. They've presented evidence that what they're saying is true. So we will continue to assess and look at it. Also, incidentally, yesterday, the defense counsel did a fantastic job of, with this last witness, going through the impeachment charges in a legal sense and getting this guy, who of course was, as I mentioned, a senior leader within the Attorney General's office, to all but agree that the impeachment charges are not legally sufficient, which was kind of hilarious. Right? You get this guy who's upper echelon AG, who was general counsel within the AG's office, which means he was the lawyer for the Attorney General's office. He was the Attorney General's lawyer within the context of the office, the lawyer's lawyer. And you get the lawyer to basically all but agree. He obviously didn't want to. He didn't want to say the words, but you could read it on his face. You could read it in his tone. You could get him to all but agree that many of the charges in the impeachment charges are legally insufficient, which was kind of hilarious. As to me, I'm holding that decision in abeyance. I'm holding that decision in abeyance because it's a question of law, and and whatever the opinion of the witness is as to the legal question, I am more than capable of reaching an independent legal judgment, sir. But it was hilarious watching this guy squirm. His conclusions, of course, as to a matter of law, are not entitled to any particular weight, but it was still hilarious. So that's where we are on all this. That's sort of the general gist of what's going on. If you want the too long didn't watch version, there is some smoke. There is some evidence. There is some reason to be concerned. But I'd still like more. And that's sort of where we're sitting. At least in my humble judgment. So hopefully that brings us to bear. Hopefully that brings us sort of up to speed. I guess in the
The Court of Impeachment of the Texas Senate is now in session. The Honorable Lieutenant Governor and President of the Senate, Dan Patrick, now presiding.
In the ultimate too long didn't watch, I suppose, they definitely have my interest, but I also want more. And I think we're continuing with the cross-examination of the lawyer's lawyer, and we'll go from there. So we'll watch him continue to get destroyed because the cross-examination has been quite effective. The guy doing cross is very good.
Mr. Little, if you want to stand over there until we do the prayer.
Dennis says they're going to sit tomorrow for the impeachment trial. I don't know whether or not that's true or not. I guess we'll find out. But if they're going to sit tomorrow, then we'll cover it tomorrow too.
We'll open with a prayer.
I was kind of looking forward to the day off, but I guess we're not doing that. So if there's impeachment trial tomorrow, then we'll do that tomorrow too.
Please pray with me. Almighty God, we pray Psalm 139 this morning. Search me, O God, and know my heart. Test me and know my anxious thoughts. See if there is any offensive way in me, and lead me in the way everlasting. Please give us wisdom and discernment beyond our own abilities. Give us the courage to stand when we must and kneel when we should. May all of our thoughts and actions today and every day bring glory and honor to our Savior Jesus Christ, in whose name we pray. Amen.
Amen. Thank you, Senator Sparks. You may be seated, everyone. Welcome to those here in the gallery. Bailiff, would you bring in the witness?
Good morning, everyone in chat. Thank you, as always, for joining me. Just a friendly reminder, if you do have the Twitters, I would particularly and really appreciate it if you would take the time to retweet the pinned link, please. I would like to help get word out of the channel and word out about what we're doing here. It costs you nothing. Please spread the, and if you don't have the Twitters, you can spread it on your social media of choice. But I would very much appreciate it if you would take the time to please retweet.
Mr. Vassar, you are still under oath. Please be seated.
Tell your friends.
Mr. Little, you may begin.
May it please the court. Thank you, Mr. President. Mr. Vassar, when we were visiting yesterday, I believe it was somewhat of an emotional day.
Can you speak up a little bit?
I'm sorry. Thank you. It was somewhat of an emotional day yesterday. You were talking about being called a rogue employee and the effect that that had on you. Do you remember?
Yes, sir.
And that, I mean, being called a rogue employee by someone you worked with was painful, yes?
Yes, sir.
Okay. Your Honor, may I approach the witness?
Yes, you may.
I'm going to show you.
Don't talk to him on the way up, though. Just.
Of course. I'm going to show you what's already been marked and admitted as Exhibit AG 170. And Mr. Arroyo, if you could bring up Exhibit AG 170 to page Brickman 190, please.
Yeah, we're still deep in cross. We're still deep in cross. This is defense counsel. This is lawyers for Paxton. And they're still on cross-examination.
Mr. Vassar, are you at page Brickman 190?
Yes, I am.
Mr. Arroyo is getting there so the jury can follow along with us.
This is Ryan Vassar. I'll put his name up on screen. Well, can I do that easily? I'll figure it out. Give me a second.
While this document is moving, Mr. Vassar, you understand you were served with a series of subpoenas by the House Board of Managers and by the Senate and by the Attorney General Ken Paxton in connection with this impeachment, true?
Yes.
And in the course of responding to that impeachment, you performed a diligent search for all the materials, of course, that were responsive to the subpoena, true?
Yes, sir.
And you didn't produce this text thread that we are looking at here at page Brickman 190, true?
I didn't have it. That's correct. It was not produced.
And you did not have it, sir, because you deleted it, correct?
No, that's not correct.
Why did you not have it?
My phone, my personal phone, through which these messages were sent, had a retention policy of 30 days to align with the Office of the Attorney General's retention policy. And so those records were automatically expunged under that retention policy.
And tell the ladies and gentlemen of the jury whether you signed what is called a litigation hold in connection with the Nate Paul investigation at the Office of the Attorney General on October 15th of 2020.
Yes,
But you did not hold this text thread that related to that investigation, true?
it did not occur to me to change the setting on my personal device, but I delivered my agency phone and laptop to Brett Webster before I was placed on investigative leave. So I presume that any information on those devices were maintained.
So this text thread, your testimony here today is this was on your work phone, true?
No, sir. This was on my personal phone, and I didn't consider changing the settings on my phone, my personal phone, which were matching the OAG's retention policy on the work devices.
And you would agree with me, of course, that these documents would be responsive to the litigation hold.
I would have to look at the litigation hold to recall what it said exactly. I remember signing it on October 15th, but I don't remember the exact categories or nature of the documents that it had mentioned.
Well, is anything related to Nate Paul, true?
Like I said, I'm happy to take a look at the document. I don't recall offhand if it was anything related to Nate Paul.
That's fine. Let's take a look at this text thread. It begins on October 20, correct?
That's right.
Yes. And yesterday, I believe you said that after you left the Attorney General's office, you had trouble finding work for 6 months. Is that right?
Yes, sir.
Do you know who Amanda Crawford is?
Yes.
Who is Amanda Crawford?
She is the current director of the Department of Information Resources.
And upon your leaving the Attorney General's office, Amanda Crawford offered you the position of General Counsel at the Texas Department of Information Resources. True?
I don't believe she offered me the job. I think she mentioned that there was a posting for the position.
And why did she mention it to you? So that you could apply?
I presume so. You would have to ask her why she mentioned it to me.
But you did, well, isn't it true that she mentioned it to you because she wanted you to apply and thought that you would get it?
I believe that could be a reasonable conclusion.
But you did not apply, correct?
I don't recall if I did or not. I don't believe I did.
You did not want that job, did you?
I don't remember at the time what my thinking was about whether I wanted the job or not.
And isn't it true that Lacey Mace also offered you a job to come with her to the state of Tennessee and work for the Attorney General's office?
I don't recall that of any official job or anything like that.
You don't recall any discussions with her about it?
No, sir.
All right. Let's take a look at this text thread here at Exhibit AG 170. It begins with a couple of, and you have to understand, these documents were produced by Blake Brickman, and it begins, and so everything in blue is Blake Brickman. Do you understand that on an iPhone?
Yes, sir.
He's the producer, and so his phone shows up blue, yes?
Yes.
There are a couple of news articles at the top. There's a quote from one of the news articles, the third text. David Maxwell below that says, "How true?" And you liked the statement from the news article about the whistleblowers in the Houston Chronicle, correct?
Yes, sir.
And moving down through it, Blake Brickman posts another article from the Texas Tribune, and Lacey May says, "Cute picture, Blake," and you post, it looks like a Batman meme. Is that right?
That's right.
This is a very somber time, yes?
That was a lighthearted effort to resemble a picture of Mr. Brickman.
Oh, that he looks like Batman? Okay. I guess we'll see. Mr. Vassar, after that, Mr. Brickman says, "From 2014, pre-LASIK." Lacey Mace laughs. Ryan Bangert says, "Handsome man." And you post a link to Twitter and a tweet that was posted by Scott Braddock, true?
Yes.
All right, we're going to jump ahead a little bit. want you to, Mr. Arroyo, could you move to page Brickman 198? And if you could join me there.
We are not going to speculate on that, Alex. That is not proper. Also, it's irrelevant, by the way, just for the record.
All right. And do you see that you made a text at 6:59 p.m. that evening?
I see the one.
Against Amplify Credit Union?
Oh, yes.
Okay.
Yes.
Mr. Arroyo, could you highlight that text for me or bring it up in Zoom? It reads, Amplify Credit Union, which held notes on 3 Paul-controlled properties and had planned to put them up for auction on Tuesday, August 4, halted its proceedings because of Paxton's opinion, Amplify CEO Kendall Garrison told the Statesman. The opinion was provided to us by an attorney for World Class that Monday, Garrison said. You posted that, correct?
Yes, sir.
But you didn't know if it was true or not, did you?
No, I quoted it. That's a quote from the article that was circulating in the text.
Yes, I understand, but you didn't know whether that was true, correct?
No,
Okay.
not at the time.
I'm going to show you a document here. Just 1 second. Do you have any experience with bankruptcy law at all?
No, sir.
Do you know what the automatic stay is?
No, sir.
Really?
Throughout your practice, you've not encountered it in the least. No?
I've heard of an automatic stay, but I couldn't explain the consequences of it for you.
You don't know what it means?
I understand it to mean that if a petition for bankruptcy is filed, it creates an automatic stay of any proceedings potentially relating to a debt or a claim. Is that a sufficient description?
It's actually really good. It would also stop a foreclosure, right?
Again, I'm not sure. I'm not a bankruptcy lawyer, so I wouldn't be able to say if it would stop it.
Do you know what times of day on the first Tuesday of the month foreclosures are required to occur under the property code?
10 a.m.?
Noon sounds right, but I don't know for sure.
Your Honor, may I approach the witness?
Was it 10 to 4? We looked it up
It's been
recently.
marked as Exhibit AG 292.
My banner has failed, Rachel. My banner has failed.
Mr. Vassar, have you ever seen Exhibit AG 292 before?
No, sir.
Can you tell at the top what time this document was filed?
It says it was filed August 4th, 2020, entered the same date, 10:48. I assume that's AM time. It doesn't have an indication.
Yep. If I told you that August 4th, 2020 was the first Tuesday of the month, would you believe me?
That sounds right.
Let's go back to Exhibit AG 170, which is this text thread here, if you would. Let's continue on. Blake Brickman responds to you. Mr. Arroyo, can you bring that back up for me?
Yeah. Also, not for nothing, of
Page
course,
break
bankruptcy
198.
is exclusively federal. So there's no particular reason that the Attorney General's office of Texas would be particularly well informed on bankruptcies, like inherently, because it's exclusively federal. That isn't, of course, to say that the Attorney General would never do something bankruptcy. It's just to say it's not Texas law. So, you know.
Blake Brickman responds, obviously just a coincidence, right? LOL. And then he had the audacity to thank the office publicly at deputies meeting later that week for stopping foreclosure on individual homes. The man is a pathological liar. Do you see that?
Or to phrase it a different way, you could be a very, very good deputy AG and know zero about bankruptcy law. It would be like asking him about patent law.
All about the people. And
You know,
David Maxwell
why are
responds,
you
all about
asking me?
himself.
I don't know.
A series of
I don't need to know. I don't
additional
want to
articles
know.
that are
That's someone else's
being,
domain.
Posted
Right.
to this group chat.
That'd be
Why do you want a
me,
group
personally.
chat in October?
It's like, you know, I know more about that than he would.
We were all friends. We were all colleagues. We all enjoyed working together. So this was just a group thread where we talked.
And if you would, Mr. Arroyo, would you bring it forward to page Brickman 200? middle of the page.
Counselor, hold on 1 second. You're a little ahead of the.
Oh, I am.
Okay,
I'm
it's
sorry.
up now. I want to be sure it's up for the jurors to read when you're quoting it.
Thank you, Mr. President. Mr. Arroyo, if you could.
There's a
zoom in on
bankruptcy
Ryan
division in the
Baxter's
AG's
text at the
office.
middle of
Yeah,
that page.
I'm sure there is. I didn't necessarily explain my point very well.
Yes, Mr. Baxter.
I'll go back to the ultimate point that I was trying to reach, is that you could be very, very good within the AG's office and know zero about bankruptcy.
Not quite so close, Eric, if you would.
So the idea that this
Capture
particular
those two
person doesn't know
texts
anything
from Ryan
about bankruptcy
Baxter in the
doesn't
middle of the
surprise
page,
me,
the one
nor is it
above that
necessarily
page.
concerning.
Thank
Was
you, Mr.
kind of what I
Arroyo.
was trying to do, but
Now,
oh
Mr.
well.
Baxter, you linked to a tweet from Lauren McGaughy on, it looks like October 25. Is that right?
I don't. Yes, it's a link to a tweet. I don't see anything about an October date, but oh, you're talking about the date that it was sent.
Yeah, it may be October 26 because
Yeah,
we're on that same thread.
yeah. If it's chronologically just with the pages, the page before Brickman 199 ends on 10/26, so it could have been 10/26 earlier in the day.
And you write hashtag sole survivor. What does that mean?
I'm not sure if it was referring to the tweet that I was referencing. It could have been an indication that I was the last remaining whistleblower who was.
How did the witness do on cross? It could have been better.
And if we can continue on in that thread, Mr. Arroyo,
For the
zoom in
witness?
on the next three texts in that thread, please.
Didn't do very great. The first half of the cross, he came off as super evasive. The second half of the cross, they started reaching into his soul a little bit.
Just right under the date stamp, if you would, please.
It was a very entertaining cross to watch. Probably not so entertaining for the witness, though.
Good man, thank you. All right. On October 26th at about 5:55 p.m., Ryan Bangert writes, yep. And Ryan Bangert writes, BW, that's Brent Webster, right?
Yes, sir.
BW just dropped by and just to be clear for ladies and gentlemen of the jury, hopefully everyone knows, but Brent Webster is the then current First Assistant Attorney General, true?
Yes, sir.
It says, Brent Webster just dropped by my office to inform me of an org chart change. I will no longer be overseeing special litigation because it will now report directly to him. And you respond, what a joke, right?
Yes, sir.
And David Maxwell responds, that's a train wreck waiting to happen. Ryan Bangert says, let him have it. And Blake Brickman writes, he is a joke. Yes?
Yes, sir.
Let's continue to the next page. If you can give me, Mr. Arroyo, maybe the gray text at the top, we'll go piece by piece. No, maybe the first 6 gray texts so we can just all see them together, if you could. Thank you. Ryan Bangert says, it will run itself. My fear is that he will force them to do crazy expletive.
No cheese. Delete your
typically how
comment.
Ryan
We're not
Bangert
going
would
to do
talk?
that.
No, sir.
I'm not going to tolerate that.
Lacey Mace says, I find that absolutely hilarious. Darren McCarty says, perfect. I've been trying to figure out how to get Patrick and Disher to join my new law firm. Is Darren McCarty one of the so-called whistleblowers?
Yes, sir.
Has he filed a lawsuit with you?
No, sir.
Because he just got out of the OAG's office and hung out a shingle, it sounds like, right?
That's my understanding.
Okay. And Ryan Bangert says, maybe Aaron can help. I'm sure Patrick and Dish will love being managed by a failed prosecutor and a third-year lawyer. That's what Ryan Bangert wrote about his coworkers, yes?
I'm sorry, say that again. Ryan Bangert.
That's what Ryan Bangert wrote about his coworkers, yes? His colleagues, yes?
Yes.
Then there's a like from Ryan Bangert, and you write, Patrick and Dish will need to start using smaller words in their pleadings. That's what you wrote, right?
Yes, sir.
You're insulting your colleagues on this familiar group chat, yes? Among friends. Yes?
It was a very.
Object non-responsive.
Witness shall answer yes or no.
You are, I'm sorry, I'll ask it again. You are insulting your colleagues on this group chat among friends, true?
I wouldn't describe it as insulting.
Witness will answer yes or no.
No. No would be the
The way that
answer.
you phrased it, no, sir.
What did you mean? First of all, just tell the ladies and gentlemen of the jury, who are Patrick and Dish?
Patrick Sweeten was in the Special Litigation Division, and Todd Disher was also in the Special Litigation Division.
And so I want to make sure the jury understands the implication of what you're saying. The implication is that Patrick and, is it Todd?
Yes, sir.
Patrick and Todd are going to need to use smaller words because their new colleagues at the Attorney General's office wouldn't understand it if they use big words, right?
That's the implication.
That is, as they say, the joke, right?
Yes, sir.
You were being funny, right?
Yeah.
Yes, sir.
Yeah.
If we could move down to the remainder of the page, Mr. Arroyo.
Yeah, that didn't really work.
Blake Brickman.
He was
says the
razzing. He
agency
was
is going to
razzing his
fall apart,
friends.
and that is one person's fault and one person only.
You know.
KP, right?
Yes, I see that.
In point of fact, the agency did not fall apart, did it?
I haven't followed it. I wouldn't know.
Lacey Mace laughs and says, or she laughs at your joke. And she says, I would love to be a fly in the wall during the special lit meetings. Can you even imagine? 4 laughing emojis, right?
Yes, sir.
And you deleted all these texts, I guess, by just a policy on your personal phone, true?
The way that you phrased it, no, sir, I did not delete them.
Well, you had a setting on your phone that deleted them, yes?
That's right.
Yeah, and not for nothing, but there is a bit of a general trend to try to make things a little bit simpler in legal documents.
A link to Amazon below that.
And a little bit more
what does that
plain
link
language.
do?
So there's that
The title
too.
is a coloring book. It looks
A
like.
coloring book, that's cute.
And the text below that says, from you, they might need some activities to keep the kids entertained, right?
Yes, sir.
You are suggesting, are you not, Mr. Vassar, that your colleagues, professional lawyers at the Office of Attorney General, might need a coloring book to stay entertained? That's what you're suggesting?
I would describe them as colleagues. I had no professional experience with them other than just the knowledge that they were new lawyers.
You didn't have any experience with the people that you are saying that might need coloring books to keep themselves entertained at the Office of Attorney General, is that true?
That's correct. It was a joke.
It was a joke.
Yeah.
I believe earlier
You
your
keep a
testimony
box of
was that
crowns
being
on your
called
desk?
A rogue employee
That's funny.
was very upsetting to you, right?
Yes, sir.
But this is how you talk about your coworkers, true?
Again, it was lighthearted. It was among friends. It was not made public to millions of people.
No one was ever supposed to see it, and certainly not the people of Texas who are watching this impeachment proceeding, right? No one was ever supposed to see this.
No one was hiding
private.
it. I'm sorry.
It was private, right?
Well, it was a conversation among friends, but I wouldn't say that any of us are concerned that it's being discussed here today.
Are you proud of this?
No, sir. That's not what I said.
No, I'm asking you now. Are you proud of this?
No. No, sir.
Let's turn the page.
Yeah, this is a little bit weak sauce right now, right? Like it's a joke among
Give
friends.
me, all the gray ones
You
at the
have
top,
you
Mr.
have
Arroyo,
dissected the
or
joke,
just
and the
first
joke has died.
6 texts so we can see it in context.
You know, so congratulations,
Lacey
I
Mace
guess.
says, ha 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 ha, in response to your text, and David Maxwell posts a laughing emoji, right? Everybody's joking, having a good time on this text thread, right?
Sure.
Nobody's appreciating the somber moment of being FBI whistleblowers at least at this time on October 26, right?
Well,
And also, not for nothing, of
lot
course,
by
but
that
people use humor. Especially, I've used
people
humor on
process
this
things in
channel,
different ways.
sometimes the
Gallows
criticism of this
crap,
channel,
right?
to diffuse tension.
yes, sir.
Okay. David Maxwell.
So sometimes specifically because it's somber, important, uncomfortable.
Today. They are excited about pursuing this
A
investigation.
person
and will
such as
coordinate their
myself
efforts with the US
might
Attorney's
use humor.
Office so that both pursuits complement each other. Who's Margaret Moore?
She was
The
previous
laughter
County
helps the
District
pain go
Attorney.
away.
So David Maxwell is calling the Travis County District Attorney at the time and the U.S. Attorney's Office, and everybody is getting fired up. They're getting excited about prosecuting Ken Paxton, right?
That appears to be what he is saying.
Next sentence says, they obviously want to move quickly as they have time constraints. They are not going to wait on the feds. What does that mean?
You'd have to ask Director Maxwell. I'm not sure what that means.
What do you think it means?
Objection to him being asked to speculate what it means, Your Honor.
Good objection.
He doesn't know. He doesn't know.
Sustained.
Thank you. I withdraw it. Now, if you look down in the rest of the thread, it says, so you know, this is Ryan Banger, so you know I tender my resignation today, effective November 4th. Darren McCarty says, thanks for letting us know. David Maxwell says, no, I didn't. Just got done at FBI. Went great. I'm staying until he fires me. We'll keep y'all posted on progress, right?
Yes, sir. I see that.
At this time, are you hoping to retain your job?
Yes, sir. I was still on investigative leave at the time.
Yes. And you're hoping to retain your job?
Yes, sir.
And ultimately, you came back to the office and talked to Brent Webster, yes?
That's right.
And you said to Brent Webster in that meeting that you still trusted the Attorney General, correct?
I believe so. I don't recall exactly what I said to Mr. Webster about trusting the Attorney General. I think what Mr. Webster asked.
Can you hold one moment?
Also, not for nothing, but I speak
We'll stand
snark.
at ease for 30 minutes.
So I speak snark. So, you know, I might talk that way among my friends, and if they let me, I might talk that way in official legal pleadings. So, you know. Who says we can't have a little fun when we're also filing official legal documents, right? Can I put in my official legal pleadings, boss, can I please put in my official legal pleadings that, you know, I have coloring books if you need them? Can I put that in the document? No, I can't? Damn it. Thank you, Catiel, for your first super chat. What's the best way to get in touch with me? Email's pretty good, I guess. Kurt at uncivillawllc.com. Don't forget the LLC part, or your email will not be answered. We'll go into the void. Emails are good. Yeah, so far, not so much on Cross today. You know, this is the weak sauce portion of the Cross. It's like, It's like, you know, isn't it true one time you told a joke? Isn't it true that this was a particularly solemn and serious moment in your life? And here you are with your japes, sir. You're japing at this serious and solemn moment when you're going to the FBI. Isn't it true? It's super serious. It's super solemn. And I'm just like, You know? What I really want to say is go F yourself. You know? But I guess I can't say that because it makes me look bad. You know? So far, the Cross is not doing anything this morning, especially compared to how it was going at the end of yesterday, in which the Cross was absolutely crushing it. And this morning it's like, let's dissect the joke. The joke isn't really funny once we really dissect it, is it? I guess not. So you don't tell good jokes, do you? You're not a humorous person. Your stand-up career isn't going very well, is it? You know, so try something else. You know, try something else. And I'll say this, by the way, just for the record, we will not on this channel speculate or even joke about anyone's potential sexuality. It is completely irrelevant. It doesn't matter, and it is not befitting of us. And also, I don't care. I don't know whether or not he's gay, and I literally don't care. It has nothing to do with anything. So we're not going to, talk about it. Excuse me 1 second. Anyway, so, yeah. So that's where we're sitting. Could it be to put the attorney, could it be in for his false sense of ease? Maybe. But, it doesn't play well, at least to me, right? Like, and, I'm just assessing it play by play. It's like, it doesn't play for me. Which, maybe it plays for somebody else, but it doesn't play for me. It's like, I don't care. Tell me something else. Tell me a different story. I don't care. That he's off, like, oh, maybe they need, a coloring book. Blessed Mom from Texas says, I'm catching up. Kurt, I'm from Texas. Hello. Do I really think Ken Paxton did something bad? I don't know. On this channel, wherever possible, we try to assess things based on the facts as presented in court. And this is an impeachment court, so, okay. In any case, we're trying to evaluate the case and the strength of the case based on the evidence presented in court. So to the extent I have an opinion, my opinion is based solely on what I've heard presented. So do I think Ken Paxton did something bad? What I can say is, based on the evidence presented so far, it appears that Ken Paxton, in my best assessment, did things that seem abnormal. I think that has been shown to my satisfaction. The reason for it is going to be the major factor. Like, Ken Paxton was doing things out of the norm. Ken Paxton was doing things that were unusual. But out of the norm isn't necessarily illegal. Unusual isn't necessarily illegal. There may be reasons for people to do things in a way that they don't normally do them. Because particular circumstances may require it. So, Ken Paxton was doing things that were odd, I believe. But why, his motivations, I don't know yet. I'll get back to you. Richard asks, what's the worst thing they're accusing him of doing? Well, in so many words, and there's more specificity, but in so many words, they're accusing him of essentially graft. They're accusing him of using his office to the personal benefit of somebody, Mr. Paul in particular. Corrupt motive, corrupt reasons, corruption of his office. He was doing things to benefit Mr. Paul for the sake of benefiting Mr. Paul, which would be illegal if true. And then, of course, the cover-up, the firing the whistleblowers, the attempt to pay them off, and so forth and so on. But that's what it boils down to. The worst thing they're accusing him of doing is corrupting his office to the benefit of Mr. Paul. which, if true, is pretty bad. You shouldn't do that. The Office of the Attorney General, by necessity, serves Texas. Texas is the client. Right? Texas is the client, not Mr. Paul. So if Mr. Paul becomes the client, that's a problem. That's a bad. That's a bad. So that's the problem. Yeah. P fraudsters, it sounds like common political practice. I can't really speak to that, and at the moment I also don't care. I've been asked to assess this particular case. So it may be, but that's also one shit defense, just generally speaking. That's a shit defense. Everyone does it, is a shit defense. That's the everyone is speeding, so you can't pull me over for speeding defense. Hey, cop, everyone on this highway is speeding. Why'd you pull me over for speeding? Everyone is doing it, is one shit defense. So if the defense is all politicians do this, that's a shit defense. Try harder. That's a shit defense. Yeah. Tired of tyranny says speed laws were in the 60s when vehicles handled a lot worse. Perhaps. I don't know. Maybe the speeding laws are bad. But it's the law. And so the speeding law is bad is not going to work. Also a pretty shit defense. Try harder. If you don't like the speeding laws, change them. If you need help figuring out who to ask, the people we're watching right now would be the people to ask. Contact your favorite state Congress critter and ask them and say the laws are bullshit. Please change them. And maybe you'll get the law changed. That's fine. But until you do that, don't come crying to me about it. You don't have enough money to bribe them? Well, that sounds like a you problem. Is it going for bad as the prosecution as the clips seem? Not really, no. The clips may be a bit unfair, but they were dramatic moments. Yeah. We have to burn away irrelevancies, to quote Captain Picard. We have to burn away irrelevancies until we arrive at a pure product, the truth. And so a lot of this is irrelevancies or of minimal value. It's entertaining to watch these crosses, but ultimately it's more sound and fury than particularly meaningful. They're laying the groundwork for things later, or at least it seems. So it has value in that sense. Or showing them to perhaps have an incomplete picture. But like, as to the substance of what the witnesses are testifying about in bulk, no, I don't think, in some senses, in some senses, it has been, at least in my generalized assessment, like I tend to believe that these witnesses believed that something was wrong. I tend to believe these witnesses had a good faith basis, which might not be particularly well informed, but still, nevertheless, right? You can observe someone's behavior, right? And so someone acting odd is a good faith reason to believe something is wrong. You know people in your life that you would be able to reach that conclusion for. You just see them acting in a weird way and you're like, okay, something is wrong. And they keep saying to you, nothing is wrong. And you're like, yeah, they're lying. Something's wrong. Their behavior is odd. They shouldn't be doing this. This doesn't make any sense. It's out of character for them. So I believe they believe that they saw something that was odd, out of character, and the Attorney General doing things that they wouldn't normally do. And so they thought something was weird and strange. I believe that. But what I still don't really know for sure is why the Attorney General is doing it. And so I'd like to hear a little bit more. They've certainly presented some evidence, at least in their view, because Mr. Paul seems to be always sort of in the background of these things. And so it's like Mr. Paul keeps showing up. And so it's like, oh, it's because of Mr. Paul, because that's the common element in the Attorney General's behavior, is not a wholly unreasonable conclusion. But it may not necessarily be the correct conclusion, so we need to hear more. Mr. Paul is a real estate developer in Austin. He is also a campaign contributor to Ken Paxton. Beyond that, I don't know who he is to Ken Paxton. It's not clear, certainly it's not clear why Ken Paxton would be particularly motivated to help Mr. Paul. I'm not sure what his motivations were. And they certainly haven't presented a lot of evidence about that yet. So we'll see. Why are we on a break? I don't know. They are. What do you want from me? You're outside of Austin, Texas? So am I. I'm on the north side of Austin. So, yeah, I'm on the north side of Austin, so. If defense uses too much time on cross, will they be barred from presenting their case? Sure will, man. And, as far as I'm concerned, God bless that. If you're given a rule, you obey the rule. The rule is you get 24 hours. It's up to you to choose how to use them, Elaine. Right? It's up to you to choose how to use them, Elaine. So if you run out of time, you run out of time. That's on you. So yeah, if they squander their time, they squander the time. Same for the prosecution, by the way, who seems to be in real danger of doing that, given their current pacing. But that's a them problem. That's a them problem for not having enough discipline to recognize the clock. The clock is your new God. You will respect the clock, and if you don't, the God will judge you, and you will be cast down. So, yes, they would be barred from presenting their case, and they should be, because they'd be morons at that point, and that's their problem. Don't be an idiot. It's like they told you in advance. They warned you. It's not a surprise. They told you. And then you're like, I didn't know. Thank you, Richard, for becoming a channel member, and thank you, Baby Meatball, for being a member for 11 months. We do appreciate everyone who joins the channel. Just a kind reminder, by the way, if you do appreciate my commentary or this channel in general, we do appreciate those who help to support us financially. And you can do so for a mere 99 cents a month. It's true. It's literally the least YouTube will let me charge you to become a member of this channel. If you hit that beautiful, beautiful join button, or you hit the link, as the bot will now tell you about, you can join the channel for 99 cents a month or more if you would prefer. You don't get anything more for higher levels, but you can show more love if you like. And for 99 cents a month, what do you get? Well, you get your name in green. You get a cool little icon by your name. You get some cool emojis. You get to chat more often because the bot doesn't restrict you as much. You also get access to some off-brand content. When I do like gaming and stuff, you can watch my gaming streams on replay and stuff. So that's kind of cool. So all that stuff. And we do appreciate everyone who is part of the channel. And if you don't have 99 cents, you can also just retweet for free if you have the Twitters, or share on your social media of choice. Because if you spread the word and more people come to the channel, that also helps the channel. And that's also appreciated. Just Me asked, how did I sleep last night? Much better. Thank you. I slept much better last night. That's good news. What games have I been playing lately? Well, I've been playing Zelda's Tears of the Kingdom on stream, which has been fantastically fun. I've been mostly like messing around and just doing shrines and stuff in no particular desire to like try to get to the end game. Just been having kind of fun. So that's been enjoyable. Starfield? I'm not familiar with the game Starfield. Let's take a look. What is a Starfield? Starfield is an action role-playing game developed by Bethesda. The game takes place in space. That could be fun. 74% people like the game. That's cool. Open world in the form of an area within the Milky Way. The player is able to land on 1,000 planets. Sounds like No Man's Sky. Ugh. Alright, I'll watch some gameplay and see if it's for me. It's Skyrim in space? Well, I enjoyed Skyrim, so maybe. It's No Man's Sky means Fallout. It might be worth a try. It has performance issues? Okay, in that case, I'll just wait. I'll wait then. Let me see if I can find out what's going on. Let's see. Texas Tribune maybe has some stuff. Let's see what's going on. Where are we? Do they have anything for today? Let's see if I can find out what's going on from one of our newspaper websites. To see if they have any information. Senator Boris Miles whispered something in Lieutenant Governor Dan Patrick's ear. Now the court is standing at ease. Okay. So there's not much information about what exactly is going on. What does Texas Tribune say? Do they have anything about it? No. CBS News? They don't seem to know why. They just declared a 30-minute break for no particular reason. Am I into politics? Not super deeply. I'm more interested in law than politics. So, politics as general, I'm not super duper into politics. I'm more interested in law than politics. We could read some book. Should we read some book? Let's read book. Let's read some book. All right. For the 500 of you who are here, we have been from time to time on stream reading a book that was written by the Colton County court reporter who thinks that they are the main character. Colton County was where the Murdaugh trial happened. Murdaugh was accused and convicted of murdering his wife and son at their home in South Carolina at Moselle. And the clerk of court, whose jobs include, reading the verdict, decided to write a book about it and basically confessed to jury tampering, which is super fun and exciting. But for the purposes of our fun and excitement, they wrote a book which is just Nobel Prize level of quality for literature. So I'm sure they will be, nominated and awarded their prize any day now because of their writing quality, which you will now get to experience for yourself. So let's see. Which chapter should we read from? Because we've been skipping around. But they're all just equally brilliant. So it doesn't matter which chapter we read from because they're all just gold. Let's read from chapter 6, Trial by Jury. Chapter 6, Trial by Jury. Quote, I consider trial by jury as the only anchor ever yet imagined by man, by which government can be held to the principles of the Constitution. Thomas Jefferson, 1788. Jury duty is one of the highest forms of public service that any American can perform. It is vital that you appear for jury service. Colton County pays its jurors $20 per day, which is as much or more than any county in South Carolina. Of course, it's significantly less money than what a full-time employee earns at their regular job. Depending on the trial's length, financial hardship comes up from the time summonses are sent until the time jurors cast their final vote of guilt or innocent. Added to the pressure, no one expected a 6-week trial in the Murdaugh murder trials. Juror names are randomly selected from a master list of names derived from a combination of the list of registered voters and lists of licensed drivers in the county. Random selection means that each name has an equal chance of being chosen. This procedure, and all other procedures related to jury selection, is conducted without reference to race, creed, gender, color, national origin, or economic status of the individual, all except citizenship. With the charges at stake, the high-profile defendant, who was also a well-known lawyer, and the international media coverage, a well-executed jury selection process was critical for the Murdaugh trial. Within a week of the verdict, Murdaugh's defense team decided to appeal the guilty verdicts based on the alleged financial misdeed evidence being allowed into the murder trial. I first learned how a financial hardship situation on the jury was averted while it was 30,000 feet in the air, flying from Charleston Airport in South Carolina to LaGuardia Airport in New York on March the 5th, 2023. I was accompanying 3 jurors so they could be interviewed live on the Today Show just a few days after I read the guilty verdict. One of the original 12 jurors who voted to convict Murdaugh almost didn't serve because of financial burdens that they'd be under. It involved the mother of his child, who lived hundreds of miles away in another state. Could you imagine the choice this young man had to make? Option number 1. Serve on the jury. Help decide the trial of the century. Risk jail time for lack of child support payments. Option 2. Stay at a regular job and maintain child support, maintain his freedom. Judge Newman, again in all of his wisdom, asked the juror to take a day and think about whether he could serve. He had a difficult relationship with his baby's mom, and had struggled in the past to meet the expectations that were on him. He did not want to risk that happening again, but was also compelled by his civic duty. I was present in Judge Newman's chambers when the juror came back the next day and said, I received an unexpected blessing. God is a God of unexpected blessings and miracles, and the entire courtroom staff was happy to hear the original juror would now be with us. What I learned on our flight to New York after the trial was that his 3 close friends of his all chipped in and paid for the financially strapped juror for his regular salary. For 6 weeks of the trial, several $1,000s. The prose just leaps off the page. Just leaps right off the page, people. This is truly the greatest writing of our time. From the Colton County clerk of court, who obviously is the main character. What if an NPC wrote a book? That's big. Okay. The jury selection process began with a summons being mailed to Colton County residents on December the 5th, 2022. The clerk's office has a mailing process when mailing the documents and summons to a jury. People in Colton County with certain qualifications randomly get correspondence. Our team would have made any Amazon distribution center or call center proud as we stuffed the following into the envelopes: a summons, 4-page questionnaire, return envelope, postage affixed to nearly 1,000 addresses. We started getting a flurry of phone calls a few days later, leading up to Christmas 2022. Mostly it was people wanting no part of being on a jury, and some could be eliminated on the phone. A few were aware it was for the Murdaugh trial, but many were not. Normally we mail out 250 for a trial and get about 25% or so to come to the courthouse for the jury pool. The judges, attorneys, and I decided on 900. Really? She decided? She was part of the decision-making team? She was part of the decision-making team that decided to send out 900? Really? Seriously? Okay. She's part of the decision-making team on how many jury summons they're going to send out. Okay. So she decided on 900 to increase the jury pool, and about 40% showed up after mailing or bringing in their answers. We communicated to the prospective jurors to come to the court at 4 different time slots on Monday, January 23rd. Jury selection ended Tuesday, January 24th. What some thought could take 2 weeks was done in 2 days. Thankfully, we had a strategic plan. Phase 1 was the prosecution and the defense teams getting to know the jurors. That was the initial questionnaire in which they provided information about if the jurors or their relatives had a history of working with legal entities or law enforcement agencies or prison systems. It also involved questions about being on a jury before a witness or being a victim of a crime. Questions also included how prospective juror consumed their media on the true crime genre, police procedural programming, and waves of podcasts and social media platforms out there. There was also a place on the questionnaire to explain why some felt they couldn't serve or be objective. Some who filled out the paperwork declared Murdaugh guilty or not guilty with their minds made up. In our world, sometimes this is an easy way to get out of jury duty instantly. Those people were disqualified for bias. In many cases, it's what they wanted. Phase 2 is not unusual in high-profile cases. Both the prosecution and the defense prepared a second and shorter questionnaire related to how much the jurors knew about the murder case, and if so, where they heard the information. As they came into the courthouse, each juror picked up a badge with their number on it, and they were handed a questionnaire before being escorted upstairs to fill it out. After they filled out the questionnaire, they would hand it to the bailiff. Then I reviewed them, and one of my clerks would make 5 copies of each, so that key legal people would have paperwork to review while putting a face to a juror number. I don't know that I can read anymore at this time. The words are of such literary quality that my soul is filled with such levels of brightness. I don't know that I can fully contemplate how full my soul is right now. So I am overwhelmed with joy and brightness, and I need to stop because it's just too much. It is just, I mean, the words are so riveting, so deep, so inspiring. I am literally awestruck. As though it were the word of God itself. The level of awe. Yeah. They're still on pause. So, anywho, it's quite possible our clerk of court friend might have done a little bit of jury tampering, and our friend Murdaugh may be getting a new trial. So that's where we're at. I suppose we could go and try to read some of the impeachment documents or read some of their briefing so that we could do something, at least more on topic, if not more meaningful. Because how could anything be more meaningful than what we were just doing? I mean, it's not even possible. But we could do something that's more on topic. So what we might do instead is, let's see, what should we do? We can do one of the motions to dismiss. We could read one of the motions to dismiss, or at least part of them. Let's see, which of the motions to dismiss do we want to read? Because obviously there's a lot of them and we don't have time. So let's see which one looks like the most promising. Maybe we'll read the one, oh no, it looks like they're actually coming back. Oh dear. We could read the motion to dismiss for Article 2 relating to the AG's opinion. Or at least read part of it. But it looks like they're coming back. The Liberty Safe thing has been interesting. Someone mentioned in chat, yeah, Liberty Safe with providing codes to the FBI. My level of offense comes from the fact that they can do it, not that they did do it. Right? The fact that there is a backdoor code is the most concerning thing to me. It's like, why would you design it that way? You didn't have to design it that way. Why would you design it that way? So, and now Liberty Safe's over here like, we'll delete your information if you ask us. Why wouldn't you just delete it all? Like why wouldn't you just delete everything? Like, be like, we screwed up. We shouldn't have done this. We'll delete our information from our database. But, I don't know. The South Carolina Attorney General has directed initiation
Mr. Miles will be here. Senator Miles will be here.
of a criminal investigation for jury tampering. Kick ass.
Mr. Little, if you want to be seated for just a moment, because I know he's in the building.
Let that trial be televised. That'd be hilarious. The trial of the clerk of court. Yeah. Yeah. Jack asked, were they ever subpoenaed for the safe information? No, they were not. I was under the impression the FBI just called them up and said, here you go. That is essentially correct. They were not under a legal subpoena. Nevertheless, my objection principally is not, my major objection is not that they gave the information to the FBI without the subpoena. My major objection is that they could give the information to the FBI without the subpoena. That is where I've chosen to express my personal outrage. So you're correct. They were not under subpoena. But that is not my principal problem.
Mr. Vassar, you're still under oath. Please be seated. Mr. Little, you may continue.
Thank you, Mr. Vassar. We're going to go back to Exhibit AG 170. Mr. Arroyo, if you could bring up page Brickman 201 again. We're going to go back one step. And if, Mr. Arroyo, if you could highlight or zoom in on the two texts at the bottom again. So, Mr. Vassar, my apologies. My colleague Amy Hilton informs me that I did not, in fact, get the joke. The joke here is this is a coloring book. It says, and I encourage anyone to look it up, it's the Going Rouge Sarah Palin Rogue Coloring and Activity Book, right?
That sounds right.
Does that look like it?
I don't recall exactly. That could be accurate.
And the joke is that Sarah Palin is so dumb that she can't spell rogue, right?
That wasn't my understanding of the joke. I believe, my recollection is that when I found a coloring book about going rogue, that was why I sent it to this group chat. I don't recall any specific reference to Sarah Palin.
That's the context of the joke, but the joke of the coloring book here is it's supposed to say going rogue, and it says going rouge, and it's Sarah Palin can't spell rogue, LOL, right?
I can't really see your phone, but I'll take your point.
Would you like me to approach so you can see it?
That's
Your
up to the president.
We are now dissecting the joke.
I see it.
We are now dissecting the joke, and
That's the one, right?
I'm dying.
I can't recall specifically if that is the one that's linked in this text message.
But the context of the joke within the text chain is it's about you going rogue. And the reference is an oblique reference to Ken Paxton calling you rogue employees, right?
Yes, sir.
And so the same information that got you very upset yesterday about being called a rogue employee, looks like 3 weeks or so after it happened, you're joking on a text chat with your friends about it and showing them the Going Rouge coloring book, right?
That's
Do I have it?
what happened. Yes, sir.
There's nothing.
Enchilada says I'm missing the larger point.
But I think I have it.
Am I? Am I missing the larger point?
I think I have it now, right? That was the context of the joke. I explained it. True?
What exactly is the larger point at this point?
I'm circulating a Amazon link to a coloring book about going rogue was what had happened.
All right, Mr. Arroyo, if you could advance to page Brickman 203. If you could start, Mr. Arroyo, with the blue text down and zoom in on that. The text from Blake Brickman says, being fired will make you a cool kid, right?
That's what he says.
David Maxwell gives a thumbs up and sunglasses emoji, right?
Yes, I see that.
Ryan Bangert responds, Brent told me today that he was, quote, completing his investigation. He said it's all based on the documents he reviewed. I told him the cold documents may tell one story, but 10 months of loved experience tell the rest of the story. And then Ryan corrects his typo and says lived. It's his lived experience that tells the story, right?
Yes, I see that.
And Darren McCartney says, definitely not loved. Ryan Bangert said, he also asked me how soon it was after RV received the signed CAMAC contract that Jeff and I learned about it.
Matt Harris is also a lawyer. Hey, Matt, I've been accused of missing the larger point. Do you know what the larger point is?
Webster was trying to investigate at this
apparently I'm missing it.
Yesterday, right, Mr. Vassar.
Do you know what the larger point of
apparently
this is?
At some point, you received the signed contract with Ken Paxton's signature on it with Brandon CAMAC, right?
Yes, I did.
And Brent Webster was trying to discover when Jeff Mateer and Ryan Bangert learned about that contract as part of his investigation. True?
That's my understanding. He didn't ask me when they learned about it, but he asked me when I received a copy of the contract.
Okay. And Ryan Bangert responds, he said that was one missing piece of his, quote, investigation, close quote. Lacey May says, he's the worst. Let's turn the page if you would. And Brent Webster, he's the new guy at the office, right?
Yes, sir.
He's been working there a little over 3 weeks maybe, or 3 weeks?
I think his first day was October 4th, and if these are on the 26th, then that would be accurate.
Okay. So next page, if you could give me, just zoom in on the text if you can, Mr. Arroyo. No, just all of the text together if you can.
Yeah, I think that's true. This molehill shall be made into a mountain. Yeah, that's
very kind.
Yeah. This is nothing. But you're trying to make it something.
Ryan Bangert posts what
which was like a major problem, like when they were doing the cross of the second witness.
I don't know how else
to me,
to it.
It was like a whole lot of nothing.
Says I never created
like the
any
cross was
documents.
pointless.
He wanted me to conduct an illegal investigation.
Desperately trying to make these things that are so inconsequential
That's right.
You know
into like huge things, and it's like I just cannot be bothered to care.
Meme, and why don't you tell the jury what you
As to the second witness, right? We discussed this.
Never interrupt your enemy when he is making a mistake.
Who is your enemy?
I didn't have an enemy at the time. It was a meme just sent in the conversation.
Sure, but there's a context, right?
Well, the context is Brent Webster was investigating us when it was General Paxton who was abusing the powers of the office to benefit Nate Paul.
And so here the context is Brent Webster is the enemy, yes?
No, sir. It's Brent Webster is investigating the wrong person or the wrong people.
Okay. Well, what's the mistake that's being made, that's being referenced in your meme here?
Oh, that would be the fact that he is investigating us, not General Paxton.
Brent Webster's making the mistake?
Yes, sir.
And you don't want to interrupt Brent Webster, right?
That was the joke. I was not in the office, so I couldn't have interrupted him if I wanted to.
You hadn't been in the office in a very long time. You were working from home, right?
No, sir. I was placed on investigative leave during this period and surrendered my official agency phone and laptop and was not permitted to access the building or work.
It seems to suggest, this meme seems to suggest to me in context that you think Brent Webster is the enemy who's making a mistake. Is that true or untrue?
I don't know what it seems to you, but I explained I didn't have an enemy at the time. I was not fighting Brent Webster.
Okay. David Maxwell posts a thumbs up and a laughing emoji. Lacey May says, so another candidate in Wilco came up. Wilco is Williamson County, right?
Yes.
And at this time, Lacey Mace is running for office, true?
I believe so.
What's she running for?
I don't recall.
So another candidate in Wilco came up to me yesterday and said, so I understand you're acquainted with Brent Webster. Let me tell you about Mr. Webster. He's lazy and he's a liar. I'm glad you don't have to work for him. And then she walked away. And you said, that's awesome. Right?
Yes, sir.
Why was that awesome?
You really?
Because I had never heard anything about Brent Webster, and to have someone approach Lacey and give their personal experience of interacting with Brent Webster, I thought was informative.
Mr. Vassar, I'm going to show you another text thread that you didn't produce, okay? But you're part of. Your Honor, may I approach the witness?
Yes, you may.
I'm not even 100% sure why it's a
Mark
problem
is
to
exhibit
consider this guy your enemy.
1006, okay?
He's at least an agent of the enemy or something. I don't know, but whatever.
Are you part of this text thread?
Yes, sir.
Have you seen it before?
Yes, I have seen it before as a participant on the thread. I've not seen these documents or this exhibit before.
Mr. President, we move for admission of AG Exhibit 1006.
Any objection?
And to be clear,
I'm
Mr.
If I
sorry,
could
I
have
didn't
just a
hear.
moment. I don't believe this is one previously that's been marked, so if I could have just a moment to look at it.
Yes, take a moment.
I mean, if you are to be believed, you believe that you've been unlawfully fired, and that this guy is illegally investigating
Your
you.
Honor, may I inquire of counsel, is it a series
so-
of communications with the different deputy chiefs?
He is the enemy.
It's
Because
just a long, but I'm trying to save time.
He's an enemy to what's
Mr.
good and
Harper,
right,
This is a text thread that was produced by Mark Penley in
and
response to you.
perhaps an unwitting enemy. Perhaps perhaps he doesn't know that he himself is
no
not
objection.
malicious, but he is the enemy
Exhibit.
because he's on the wrong side of what's good and decent,
Number,
right?
Mr. Little?
So I don't know.
1006.
It is,
Into
Mr.
evidence?
President. May I proceed?
Yes.
Thank you. Mr. Vassar, take a look at, and Mr. Arroyo, would you please bring up Exhibit 1006 so the jury
Yeah.
can see it with us? Go to the first page of that if you would. You're on the second. There you go. All right, thank you. Mr. Vassar, you post a picture into this text thread, right?
Yes, sir.
And you're posting a picture of an email from Ken Paxton to a group chat, yes?
Yes, sir.
And Ken Paxton telling you, I did sign the outside counsel contract with Camac Law Firm, PLLC, yes?
That's right.
And who is, if you can tell the ladies and gentlemen of the jury, who is on this text thread?
It's myself, David Maxwell, Ryan Bangert, Blake Brickman, and Lacey Mace. Just going by their...
And this is hard to tell with iPhones, but this document was produced by Mark Penley, so these are screenshots of Mark Penley's phone. Do you understand he's on the thread too?
Okay, I don't see him. I understand that now. He wasn't listed in the little bubbles at the top, but I understand.
Well, my experience with this, obviously I'm not testifying, but you know how on iPhones when you're on a group chat, it doesn't necessarily put you in the little circle.
Right.
If it's your phone, right?
Okay.
So Mark is on this thread?
It appears so.
Okay. So Lacey Mace, second text, new group. Do you see that?
Yes, sir.
And the date of this, just to be clear, it begins on October 2 of 2020, right? Right after you went to the FBI?
That's right.
All right. Let's see what you're talking about. Turn to the next page, if you would. The next page is a picture from Ryan Vassar. It says, silence unknown callers. And he says, y'all, and you say, I'm sorry, it's a text from you. You say, you show them a picture of the silence unknown callers feature on your phone. You say,
Jeff
"Y'all
says,
should probably
I was told
turn
in
this
Pennsylvania
feature on,"
texts are inadmissible.
right?
That's right.
And why do you say that?
That doesn't sound right.
To avoid receiving a phone call from a blocked number or an unknown number that was unanticipated or unexpected.
And you're worried about media calls at this point, right?
It could have been any calls, any unknown or unidentified calls.
And Ryan Bangert says, how did I not know about that until now? And Lacey May says, excellent. The next, and let's turn the page, if you would, Mr. Arroyo, to page Penley 9. You say we should consider notifying.
Speak
other
Life
guests
says, what
before
duties is the
Monday.
Senate
Notifying
abandoning to be
what?
present? None. The Senate is not in session.
The fact that we had
So
gone to report
they are not
General Paxton to law enforcement
abandoning any
about
duties to
the
be here.
facts that we had determined
That's not what you say.
to
Excuse me, I object to the sidebar and testifying, Your Honor. He can ask questions, but not state as if
Sustained.
he's testifying. Thank you.
Lacey Mace responds to you about the new FA, and she means first assistant, right?
Yes, I believe so.
And then she says, I don't feel like that's our announcement to make. And you say, resigning. Resigning.
Right. So
What you said, we should consider notifying other DEPs before Monday. It's about resigning. Yes?
that was a element of it, but most of it was about going to law enforcement to report General Paxton's activities that we had determined.
That's not what you say in this text thread, is it?
No, what I just explained is that is part of the conversation that we're having at the time.
As of October 2, you were planning to resign as a group, yes?
No, sir. We were discussing what we should do.
And you were saying we should consider notifying the other deputies before Monday about resigning. True?
That's right. In addition to disclosing to them that we had gone to law enforcement to report General Paxton's activities.
Ryan Banger responds, I don't think we tell them until we have a fully vetted plan of action. Next page. Blake Brickman says, has anybody updated Johnny? Who's Johnny?
You have to ask Blake, but I interpreted that as Johnny Sutton.
Is he representing all of you at this point?
Yes, sir.
Who's paying for all that, by the way?
Well, we are.
Did you pay for it out of your savings?
I've not paid Mr. Sutton.
Whoa. Who has?
Nobody has. He's agreed to bill us at a future date.
What future date?
You'd have to ask him.
You're telling me that an attorney, a very experienced, prominent criminal defense attorney, decided to do this for free, for you, for 3 years. Is that right?
No, sir. It's not for free.
What's the arrangement?
We will pay him for the services that he's rendered to us.
Is he billing you hourly?
He's recording his hours, is my understanding. I have not received a bill from him.
And he hasn't been paid by any of you yet. Is that right?
I have not paid him. I'm not aware of whether any other individuals have paid him.
And so is the plan for you to achieve this settlement through the adoption of the Texas legislature and then pay off your criminal attorney who is trying to help you not be labeled co-conspirators? Is that the plan?
No, that's never been discussed.
When are you going to have the money?
Ideally, when I have enough money, I can pay him.
But you've never been sent a bill. You don't even know what to pay him.
That's right.
Is everybody paying equally? Is it pro rata?
Again, I'm not sure what other people's arrangements have been, but I have not received a bill from Mr. Sutton, and I have not paid him yet.
How did you find this fellow, by the way?
Mr. Sutton?
Yes.
His name had been discussed with Mr. Matier and Mr. Bangert and Mr. McCarty about the best person to call before we had met with law enforcement.
Who suggested him first?
I don't recall exactly.
Yeah. It's actually even slightly
Did you
worse than
understand
chat
Mr.
is
Sutton to be
suggesting,
a former U.S. attorney?
because
Yes, sir.
In whose administration, if you would?
it's arguably
I believe it was George.
it's
W.
arguably
Bush's
from an ethics
administration.
perspective a contingency fee, which you can't do in a criminal case, right?
Have you ever heard the expression, there are no coincidences in Austin?
Oh my God, please stop asking about this phrase.
I
don't fucking care.
Recall it right now.
Yeah. It's arguably a contingency
text you
fee
write-
because,
or
like, I'm not going to
response
bill
Blake
you
Brickman,
until some future
you say,
date.
not me.
And
You
then
haven't updated John
if we
Sutton
don't
yet,
win,
right?
I'm going to just forgive your debt.
That's right.
So basically, it becomes a
Ryan Banger
contingency
says,
fee.
not with the latest. He is aware that
So
Jeff
it's
resigned, but
ethically
not the new
questionable.
FAAH or FAAG. Is that supposed to be First Assistant Attorney General?
That's right.
Okay. Next page, if you would. You write, to-do list. 1, update Johnny. That's Johnny Sutton, right?
That's right.
And number 2 is have someone call the new meat, right?
That's right.
Who's the new meat?
I have no idea. I don't recall who I was referring to at that time.
You're talking about new employees at the Attorney General's office, right?
I'm not sure.
Can't tell.
I presume
Yeah,
that would have
Matthew,
been
exactly.
people that I
Yeah,
was
contingency
referring
fee in a criminal case is the
Just
fastest way to
based
get
on
an email from
being in the
disciplinary
office
counsel.
and working
And I'm like, yeah.
office.
So
Number 3 is discuss
I'm like, wait a
with
second.
Luis,
He
tell
isn't
the
billing
jury
you.
who Luis is.
He isn't billing
At the
you,
time, Mr. Luis signs,
and he
was
won't
the
bill you until
chief of
some
staff
future
for
date.
Governor Abbott.
What were you going to be
And I'm
discussing
like,
with Governor Abbott's?
That could be
It was
recharacterized
not
as a
my
contingency
discussion.
fee,
It was a to-do
which is
list
ethically
that
questionable.
Members of the group
Well,
had
more to the point, if it
contributed
is a
to.
contingency fee, it's
So I
ethically
did not
forbidden.
meet, I did not talk to.
So I'm
I
like,
did not confer with Mr. Science.
yeah,
Who did?
I'm not. I
yeah.
don't know. I believe Mr. Banger and Mr. Mateer met with Luis, but I
So,
don't know.
you got
where
my
or
attention.
when.
Well, I want to be super clear about the timeline, okay? Without telling you anything that's been testified to in this trial. Are you
Peggy
aware
says, can he
of
work for free?
any
He can
type
work for
of
free.
Meeting between
So he
Mr.
can work for
Mr.
free.
Banger and the governor's office on the day of the
That would be
FBI
fine.
report.
He can bill it. He can bill at any rate he likes.
I can't
So if
say
he
that I
wants to bill
recall.
at zero,
I
he
don't
can
know
bill at
when
zero. That's fine.
Or where they made.
But what
that.
he can't do
But the
is make a
discussion that's
contingent.
contemplated in your text message with Luis
He
Sines.
can't say, well, I'm billing at $300 an hour,
That was
and I'm going to
said
bill
that.
you at a later time,
The
but wink,
discussion
wink,
with
wink.
Luis
If we
Sines
don't
that's
win,
contemplated in your text
I won't
message
bill you.
is not talking about
That he
because
can't
this
do.
is on October 2. So this is talking about a new meeting with the governor's chief of staff, right?
So,
Again,
yeah.
I don't know for sure. I don't
Because
I
it's a
was part of
criminal
the meeting.
case.
I
You
don't
can't
know
do
when it happened
contingencies
or where
in
it
criminal or
occurred,
divorce
and
cases.
I don't recall.
It's
if this was
unethical.
referring to that specific meeting or a subsequent meeting.
Number 4 on your to-do list, coordinate group office cleanout, right?
Yes, sir.
You are planning as a group to clean out your offices, yes?
Again, that was the conversation that we were having at the time.
But at some point in time, I'm sure you retained an employment lawyer and someone advised you that you need to stick around and make them fire you, right?
I did hire an employment lawyer.
And at some point in time, after meeting the employment lawyer, you decided the best thing to do was stick around and make somebody fire you, yes?
I don't recall if that was the decision that was reached with my employment lawyer.
Your plan on October 2 was to coordinate a group office cleanout, yes?
That was the conversation we were having, again, about options, discussing continuity of the office, and whether it was an option for us to resign.
The next text is from, it appears to me to be Mark Penley, because this is his text thread. It says, Ryan B., did you find the sets of subpoenas in my office? Do you see that?
I see that.
These are the grand jury subpoenas, yes?
I would presume so. You'd have to ask Mark which subpoenas he was referring
Can
to.
lawyers donate their time?
Banger responds,
Yes.
I've not been down to grab them yet.
A lawyer
I
can
likely
bill
will
at
get them
zero.
this morning. Let's turn, and he says, I know
It's called
Johnny
pro bono.
has, and let's turn to the next page, them, so we can always get a copy from him.
So
once it
yes, you
comes
can
to
bill
us.
at zero,
I'm
but
apparently not locked out yet. And then Ryan posts a tweet from Lauren McGaughy, right?
you know,
Yes, I see that.
And who's Lauren McGaughy?
that would be clear up
She's a
front.
reporter for the Dallas.
I'm doing it for free.
You see her up here? You see her back there?
I don't know. I've never met her.
But that isn't
Never met.
exactly what's going on.
Well, she was on top of it. This
You know?
she's got a tweet here. It says, I heard First Assistant Attorney General Jeff Mateer announced today he's leaving the agency to return to First Liberty. And then the next text from Ryan B. is, Lauren McGaughy knows.
So I'm like,
She's a vigilant
you know, this
reporter,
could be viewed as a contingency fee with
not
extra steps.
That was not public at that point in time, right?
I'm not sure either. I am not sure of the timeline between when this was sent or when it looks like the tweet occurred on October 2nd at 7:15 p.m.
All right, let's turn the page if you would. You write, what she needs now is a statement from First Liberty, right?
That's right.
What Lauren, the Dallas Morning News reporter, needs now is a statement from First Liberty is what you're saying, yes?
That's what I would have suggested, yes, sir.
Yeah, and so, correct me if I'm wrong, Mr. Vassar, it kind of looks like you're trying to shape the media narrative around what's going on. Is that true?
No, sir.
But what you're saying here is we should try to get her a statement from First Liberty, right?
Absolutely not.
That's not what you mean?
No, sir.
What did you mean? Just tell the ladies and gentlemen of the jury.
That was my personal observation of another piece of information that she could obtain was a statement from First Liberty, which is where I understand Mr. Mateer was going to work.
And Ryan Bangert responds, or Alejandro can just give our statement. Who's Alejandro?
He was the communications director at the office at the time.
So you got this lawyer
And you say, unless
who apparently is representing 8 people in a criminal
case.
case,
What's the
and
black
apparently not billing any of
It's
them
my understanding at the office
with bills
that
to come
there was a list of
at a later
reporters
date.
that were handled differently than other reporters.
That would be what we call, for example,
Text.
looking
On
suspicious,
second thought, let the
right?
media
In the
feeding
same
frenzy
way that,
start.
for
Who
example,
said that?
these lawyers
That was
thought that
Ryan
something
Bangert.
might be a little bit rotten in the
same
state
lawyer
of
that
Denmark.
testified in the
I'm
trial?
looking at this and
That
like,
guy?
I think this is a little sus. You
So
got a
October
guy
2,
who's working
he's
as a
saying,
criminal lawyer for 8
let
different
the media
people
feed
in a
frenzy.
fairly high profile case
Yes,
in a
that's
criminal
what he said.
context,
This is-
not billing any of them
How many
to be
days is this
billed
after
at a
the
later
FBI
date.
No evidence.
Well, to
My
clarify,
spidey sense says something might be wrong here.
absence of evidence that I was referring to is documents. What we went with is our
Not
personal.
responsive. Object, not responsive, Your Honor.
Sustained. I'm sorry. I did not hear you.
Why did Ryan Bangert want to start a media feeding frenzy on October 2?
You'd have to ask him that. I'm not sure.
And apparently, even like stranger to me somehow, is the fact that apparently he's not getting any like periodic statements as to how much his lawyer is billing him, which is even weirder to me
Go
somehow.
to page Penley 20.
Because he's like, I don't know how many hours. He's like, I don't know how many hours my attorney's billing. I'm like, really? You don't know? Your attorney isn't sending you like a monthly statement or a quarterly statement
I want
with
you to look
here's
at the-
how
I want
much
you to zoom in on
it's
the last
costing
text
so
on this
far,
one.
FYI, to the client. Isn't that kind of odd that the lawyer isn't sending you a periodic billing with, by the, or at least a
It says
periodic,
stand down on
a
that.
periodic
Ignore that
statement
because he
that
told me
says,
he
by
was
the
in
way,
AM
here's how much debt you've
blank.
accumulated so
Redacted
far,
name.
just to let you know.
Blank was actually in the office
For
while
3
he was
years, he
there.
hasn't been telling you how much he's been billing or how much it's been costing you, and you haven't
I'm not
asked?
sure. I don't recall.
Isn't that a little strange? Seems a little strange to me.
That would have been. That was a message from, looks like Lacey.
And if you could, Mr. Arroyo, advance to page Penley 25.
Is that even ethical? Is that even ethical to, like, you know, not send the client some sort of periodic notifications
And you
with
say,
respect
"We
to
need a
how
statement."
much it's costing you?
That's right.
Is that ethical?
You wrote a long one. So look to the bottom of that page. Mr. Arroyo, next page. Next page after that. Next page after that. Next page after that.
Robert says, what happens when the criminal defense
Talk
attorney
about
needs to
not
sacrifice one of the
tiring
clients to
in
save the
pursuit of
rest?
Justice will
Well,
be
he
served.
would need to
Refuse
withdraw
resign and will not
from
be
future
intimidated.
representation.
You say all
Of
that, right?
He can't, once their interests
among
become
other
adverse to
things,
each
yes,
other,
sir.
he would need to withdraw
Yes?
Yes, sir.
Why
as
do
the
you wanna
attorney
do that?
for
Why
at
do you wanna
least
release a statement?
one of them.
Because it was in response to the Attorney General's allegations.
He would need to sever out the cases
that
once their
we
interests
had
become adverse.
authorized the activities that he was directing and supervising throughout the year that related to Nate Paul.
And no one on this thread agrees with you, right?
Yeah. Matt says this lawyer's lawyer needs a lawyer.
I don't know that anyone
Yeah.
disagreed with the content, but no one decided to issue it.
Next page, if you would, please.
Is the state bar paying attention? I would imagine there's got to be some people from the state bar who are watching this hearing.
Very hard on our behalf.
Counselor, hold on. It's not on the screen.
Does that strike anyone at the state bar just a little odd?
If you would,
That he's
Mr.
worked
Rowe,
for
that middle
3
text.
years and apparently never sent his client a statement regarding how much it's costing,
Middle text says it's likely that a very
or how many hours he's billed.
person is working
3
very hard on our
hours,
behalf as we speak.
3 years,
Yes, I see that.
with what would have to be at the end of this the worst surprise billing in the history of ever.
Were you paying for a crisis comms person?
That's ethical. I have questions.
Did you ever ask her who she was talking about?
Pardon me, Your Honor. Can I ask the witness to speak a little closer to the microphone? Thank you.
Yes, please.
Did you ever ask her who she was talking about?
No, sir.
Okay.
Too High Strung says, I've used a criminal lawyer 3 times here in Cali. There's 3 contingency options based on the outcome of the case. And I had acknowledged the acknowledgement of different rates before he reps. Well, without knowing exactly what you're talking about, here's what I think you're talking about.
This is marked as
And you can correct me if this is not true. But what you can do as a lawyer is you can set up different scopes of representation.
Yes, you may.
So what would be ethical for an attorney to do would be something like, I will represent you through the end of the trial for $100,000. If this goes to appeal, then I will represent you for another $100,000. Right? So you can do that because that's about the scope of the representation, right? If
Please review this email thread.
I will represent you through an
One
initial
moment.
motion to
Mr. Hardin, have you
dismiss,
had an opportunity to look at it?
that will cost you X.
I have no objection.
If that fails, I will represent you through the end of the trial. That will cost you X.
It is admitted to.
If that fails, I'll represent you through the end of the appeal. That I'll call X. That is fine. That's ethical.
It's an email that was printed by Brent Webster.
Because you're defining the scope of the
It was sent
representation.
From Lacey Mays to myself on October 1st, 2020.
Mr. Arroyo, if you would, please. Exhibit AG 1007. Zoom in on the text, if you would, please.
Sherry says, do lawyers ever take on high-profile cases pro bono
All right.
simply for
Make sure
bona
we have
fides?
perfect context.
Sure.
All right.
For professional, for clout?
Earlier
Sure.
email in the thread is from a
Yeah,
woman named
attorneys
Brittany
will do
Hornsey.
stuff at lower rates or discount
that?
rates or even free because the
At time,
publicity
she
is
was
worth it. Sure.
Executive assistant to Jeff Mateer.
Jeff Mateer only.
Which is
He's got
also
his own
fine.
assistant?
I believe she also supported Ryan Bangert, but I'm not sure exactly.
Okay. And
For 3 years?
he writes an
Maybe.
email on September 30th at
Yeah, maybe.
6:16 p.m. Yes.
Yes,
And to whom did she write it?
to Ms. Mays.
And what is the subject?
It says letter.
All right, put this in proper timeline for the jury. At 6:16 p.m. on September 30th of 2020, you have already made your report to the Federal Bureau of Investigation, yes?
Yes,
And Brittany Hornsey is emailing something to Lacey Mace, yes?
that's what this indicates, yes.
In October 1, the next day, 30 days hath October, yes, the next
Is a contract agreement between a lawyer and client protected by
12:09
privilege?
PM, Lacey Mace forwards that item to you, yes?
Yes.
Let's show the ladies and gentlemen.
I'm
of the jury
not
what that
100%
item is, Mr.
sure.
Vassar. Next page.
I can tell you I can tell you that typically, although there are exceptions, the mere fact that I represent somebody
you
is
may
not
identify
itself
it.
privileged.
Or was there a question?
So the fact this guy is my client
What is it?
is not normally privileged.
It
Is
says
the retention
draft
agreement
2.
privileged?
It's dated September 29th, 2020. It has
I
the
honestly
Attorney
don't know off the top of my
General's
head. It's
seal
never
on top
come
of
up.
it, and it has no body, but it is a draft signature block of
But of course,
executive deputies.
this guy
What
is the
else do you
attorney's
notice
attorney's
about it?
attorney, and surely he
There are
would
some
know
signatures
if
and
it's
some that are
privileged.
not. There
And
are
so he could say, I won't answer the question because of privilege.
I think that's it.
But apparently he's not invoking his own privilege. So I guess he's knowingly waiving it, so it's okay. So
Not offhand, no, sir.
yeah.
The Attorney General's name has been removed from the letterhead.
Matt, is a retention agreement privileged?
As I explained yesterday, the agency has different letterhead. This is a different letterhead.
You understand that Brittany Hornsey was interviewed by Brent Webster as part of this case?
I'm not advised, but
Have you heard that Brittany Hornsey was intentionally told by Lacey Mace?
I've not heard that.
Stop. I didn't finish my question.
Sorry.
Hold on a second. Have you heard that Brittany Hornsey was intentionally told by Lacey Mace to bring her the letterhead without Ken Paxton's name on it?
I'm not sure that I have ever heard that Lacey had instructed Brittany to send the letterhead.
I think the answer is no.
Had you ever before?
I think the answer is
written a
no
letter
because it doesn't relate to
agency
information you're
letterhead?
getting from your client.
Skip it.
So I think no, it's not privileged? Question mark?
This, of course, letterhead was being used in the letter by the so-called whistleblowers to notify certain parties of certain things. Yes.
It's never come up.
right.
I've never had to ask the question. Yeah. I've never had to ask the question, so I don't know, because I've never had to think about it before.
I want to go back in time a little bit. We've been talking a lot about September or October, but I want to go back to the hiring of Brandon Kamak, okay? Ask you a series of questions that I
Matt
think
says
are
a fee
all
agreement is certainly
related
confidential,
to
and I do believe they're
Okay.
privileged.
You
How
were
if attorney
responsible
fees are
for
relevant, then
overseeing
fee
outside
agreement is
counsel
disclosed.
contracts,
Fair enough.
Correct.
For the Office of the Attorney General, that was one of the areas, yes, sir.
Yes. And the agency reviews and approves around 900 of them every 2 years. True?
Yes, across the state,
Okay.
not for the office.
I want to put things in proper context. Brandon Kamak would have been one outside counsel out of about 900 between 2019 and 2020. True?
Yes. On average, yes. There's about 900 outside counsel contracts that the agency processes on behalf of other state agencies. The office itself might have 2 to 5 outside counsel contracts at a time, is my recollection.
So if the suggestion is that Nate Paul had such a chokehold on the Attorney General's office that he had consumed so many resources that the office wasn't really doing much else, that wouldn't be true, would it?
The focus of Nate Paul's related activities were becoming increasingly...
Subject non-responsive, Mr. President.
Matt says, I fight the disclosure of fee agreements in cases where recovery of attorney's
It
fees
is
is not
not
an issue.
true, Mr.
There's a State
Vassar,
Farm Lloyd's
that Nate
case
Paul had such
on
a
non-disclosure if
stranglehold
not
on the
relevant.
Office of Attorney General that nothing else was getting done, right?
I wouldn't characterize it that way.
Yeah, but
All right,
in
let
that
me ask you
situation,
question.
you're treating it as
Yes or no?
confidential, which is
Did Nate Paul
fine.
have such a stranglehold
And
on the
your
Office of
your
the Attorney
objection
General
is
that other
relevance,
things weren't
not
getting done?
privilege.
I don't think I can answer.
So
the
I
yes or no
understand, like,
question.
I'm not going to tell you because it's not relevant.
Are you sure?
I am sure.
So
But,
you can't say yes, right?
well, I think we've exhausted this topic enough. Let's move on.
You can't say yes, right?
The degree to which Nate Paul's relationship with General Paxton and the activities that
Object
we
not
were asking...
responsive.
Objection, Your Honor. He can't put these, object to him being forced to answer yes or no. The rules don't require that from a witness if they can't. And he's trying to testify in these questions. When he doesn't get what he wants, he asks him to just give yes or no. That question, if you look at it, we have no idea what he means by stranglehold, as an example. He should not be required to answer yes or no before he knows what this man means. That's my objection.
Yeah, Marie says it's cross, and I'm like, yeah, that goes a long way.
First, I think you had an objection first, then you had an objection.
Yes, sir.
I believe so. Okay. The court reporters, I hope you were able to get that. We had objections over each other. So first of all, we will overrule your objection. We will sustain your objection. To the best of your ability, Mr. Vassar, if you can answer yes or no, continue.
Try to ask a better question. How many lawyers are there roughly at the Office of the Attorney General?
Roughly 800 lawyers.
How many of them ever touched anything related to Nate Paul? How many of the 800 ever touched anything related to Nate Paul?
He would have no idea.
Could speculate there may have been 15 lawyers, maybe 15 to 20.
How many cases does the Attorney General's office have going on at any time?
Lots.
Generally, I think it's around 900,000 or maybe 50,000 cases.
900,000 or 50,000?
Well,
help me out here.
I was going back to the outside counsel numbers of 900 every 2 years, so I apologize. I was not in the civil litigation division, so I'm not sure how many litigation cases are active at any general moment.
How many? What's your best understanding of how many civil litigation matters are going at the Office of the Attorney General at any given time?
Possibly, it could be 20,000 active cases at a time.
20,000, right? And how many of those 20,000 cases involve Nate Paul?
I would have no direct knowledge of how many of those cases would.
So I think we've been over this a lot. I don't want to burden us with it too much longer. There's a layering of signatures and approvals as part of the policy for hiring outside counsel. Yes?
Yes, sir.
But of course, you know that the law says that the elected Attorney General appoints outside counsel, right? Just him, right?
No, sir.
All right, Mr. Arroyo, this may be challenging for you to find, but please bring up section 402.0212 of the Texas Government Code. Eric on the spot. All right, give me the title in section A, please. Have you ever read this before?
Yes, sir.
Let's read it together. It says, except as authorized by other law, a contract for legal services between an attorney other than a full-time employee of the agency and a state agency in the executive department other than an agency established by the Texas Constitution must be approved by the Attorney General to be valid, right?
Yes, sir.
That's pretty clear, isn't it?
Yes, sir.
Doesn't have to be approved by you. Doesn't have to be approved by Jeff Mateer. Doesn't have to be approved by Michelle Price. Doesn't have to be approved by Lacey Mace or Ryan Bangert or anybody else but the guy who got 4.2 million votes, right?
It was a standard practice for approvals, but yes.
Tech non-responsive.
Sustained.
Right?
Your initial question was whether the law allows General Paxton to appoint outside or
Tech non-responsive, Mr. President.
Sustained.
You'd like to have the court reporter read the question back to you.
Your first question about whether the law allows.
Object non-responsive.
Sustained.
Yes, please read the question back to me.
We could not hear that. Can you repeat that?
I'll be happy to repeat it. Outside counsel contracts don't have to be approved by you. They don't have to be approved by Jeff Mateer. They don't have to be approved by Michelle Price or Lacey Mace or Ryan Bangert or anyone but the guy who got 4.2 million votes, right?
That's right.
Thank you.
There you go.
Now, with regard to criminal matters, you had a call with General Paxton, true?
Specific to the outside counsel process, yes, but in general criminal matters, no.
Just me asked, did I get a chance to look at my Venmo?
Yes,
I got a couple of Venmos last night, but I'll take another look at them just to make sure, because we do want to thank everyone who helps to donate to the channel, as always.
Right?
Yes, sir.
Remember,
And we read some of these yesterday, but we can read them again because we don't mind
And
giving,
he was asking for your advice.
you know,
Yes.
nice thoughts to people.
Asking me to explain.
Lynn gave $20 via Venmo.
Now,
Nikki
this next
gave
question
$10 via Venmo. William
Paxton
gave
asked,
$200
and I quote,
via Venmo. Thank you very much.
Can the agency retain outside counsel? in
And
criminal
those were the
matters?
donations yesterday. Thank you very much.
That's right.
He asked for your advice, right?
Yes.
He didn't kick down your door and say, Ryan, this is what we're doing, did he?
Not in that conversation.
He asked you for your advice, and you gave him your advice, true?
Yes.
You called two candidates, Joe Brown and Brandon Kamak, correct?
Yes, sir.
You got each of them to run a conflict check, true?
Yes, sir.
You drafted a contract for Joe Brown, didn't you?
No, sir. I sent Mr. Brown the template, the outside counsel contract template, with no scope. There was no scope of work, no rate of pay, and his follow-up email to me was, would you like me to draft the scope?
And you said, Joe, the malpractice issue may be one that we can resolve. We will draft the scope, and we'll send you a draft agreement with the relevant details as soon as possible, right?
That's right.
You got each of them to run a conflicts check, Brown and Kamak, right?
Yes.
Now, in your estimation, the Nate Paul investigative referral from the Travis County District Attorney's Office was, and I quote, an ordinary criminal referral with ordinary investigative issues. True?
That was my perception, yes, sir.
Your conversations with First Assistant Jeff, actually, let me press pause here.
Thank you, Sandy. I'll deal with those on a
Did you
break.
go back and watch the video of yourself giving testimony?
No, sir.
Okay. Your conversations with First Assistant Jeff Mateer were that you could make a legal argument that this outside counsel contract with Kamak was okay because you had a referral and you had separate authority to engage outside counsel. True?
Yes, sir.
And you drafted Kamak's contract, true?
Yes, sir.
Now, tell the ladies and gentlemen of the jury, because I think we all want to understand the executive action memorandum. The whole process or whole idea of using what's called workflow in DocuSign for these outside counsel contracts was your idea, wasn't it?
Yes, sir.
Doesn't date back to John Corden or Greg Abbott, does it?
No, sir.
You're the progenitor of this idea, and we have you to thank for it, I suppose, right?
I suppose so.
And so what happens in workflow DocuSign is one person has to sign and then the next person, and it has to go in order. True?
Yes, sir.
Didn't exist before you. Yes?
It existed in hard copy, but not electronic copy.
Jeff Mateer told you to sign this contract. Yes?
Yes, sir, he did.
Not Ken Paxton. Jeff Mateer told you to sign this contract with Brandon Kamak, right?
In my conversations with Jeff,
No one but Jeff Mateer told you to sign this contract, right? Right?
Jeff Mateer was the only person that I had spoke to about signing the contract.
Ken Paxton didn't cause you or compel you to sign it, did he?
No, sir.
Your conversation with Mateer, in fact, was, and I quote, "We need to keep this on as short of a leash as possible because we don't want it running away." True?
No, sir. That's not true.
Well, fortunately, we have your transcript.
I
Mr.
think-
President, may I approach the witness?
You may.
All right, so this is a lot more effective than whatever joke dissection we were doing earlier. So I appreciate this much more.
Mr. President, I am not moving for admission of this transcript as I do not think it will be necessary. The purpose of this is impeachment only.
Very well.
May I inquire, excuse me, go ahead. May I inquire if you intend to introduce the entire document?
I do not. I just said that. I don't intend to introduce it as an exhibit. I intend to use it for impeachment purposes only.
I have nothing. Thank you, Judge.
Continue.
If you would, turn to page 105 of your transcript. I'm going to bring it up as well. We're not going to put it on the screen because I don't think we'll need to do that.
Yeah, he did just explain it. And, yeah. So, yeah, he literally said, I'm going to introduce it for, it's like, well, which portion are you going to admit?
Can you find page 105?
It's like, none. I'm just going to offer it for impeachment.
On the transcript page of 105. Yes, sir.
Read for the ladies and gentlemen of the jury what you testified to the House Board
Counselor, hold on one second. My transcript is down. I'm just trying to get it back up. Hold on. Go ahead.
Thank you, Mr. President. Read, if you would, Mr. Vassar, to the ladies and gentlemen of this jury, the testimony that you gave to the House Board of Managers beginning at page 105, line 24, and read until page 106, line 4.
So it says, and my conversations with Mateer, similar to the qualifications, the expertise, the experience between the two potential people, along those same lines was, quote, we need to keep
cross-examination does count against the number of hours, yes.
Don't want it running away, close quote.
And you had that conversation with Jeff Mateer, didn't you?
So, yeah, cross does burn your time.
Several conversations with
As
Mr.
it should.
Mateer.
Jack, non-responsive.
Sustained.
Had that conversation with Mr. Mateer, didn't you?
Yes, I had a conversation with Mr. Mateer, but at no point did I say...
Jack, non-responsive.
Excuse me, please be allowed to respond to his question.
Overruled.
Can you repeat the question to me?
You had the conversation that you described here in your testimony to the House Board of Managers with Mr. Mateer, yes?
Yes, sir, I had a conversation.
Thank you. And you made an intentional decision to bring Brandon Kamak on as, I believe you put it, a third set of eyes, yes?
No, sir, I didn't make the decision. I provided a recommendation and a legal justification to do so.
Fair enough. I'll take the distinction.
If you look at page 106, lines 5 through 11, what you say is, so I drafted the scope of work for the contract. You're talking about Kamak's contract.
Pardon me, Your Honor. May we approach the bench, please?
Yes,
No.
sir.
I don't know what they're talking about right now. I note that the lieutenant governor and I have different styles of looking at stuff. I also note the lieutenant governor, of course, is not a lawyer, so that could be partly what's going on there. Although that doesn't necessarily mean anything. I've disagreed with many a judge, too. There is a little bit of artistry in the whole thing. I'm like, well, I wouldn't necessarily do it that way, you know. It's one of those interesting things, like how much is up to like the judge's own style, temperaments, interests. That's why rule number 1 of litigation is don't piss off the judge, because the judge, for better or worse, is a demigod, and you would be well advised to remember it. The judge gets a lot of latitude in
I think the two of you have come to agreement of moving forward.
We
in a
have.
proper
in
way,
how
in a
they
proper way.
how they
Mr.
run their
Harden will Let me
courtroom.
know if I mess up.
Yeah. It may be the closest thing to a king that we have in our system
Members
of
of the jury,
government.
come to order.
So
So, Mr. Vassar, the plan was to bring on Mr. Kamak as, I believe you put it, a third set of eyes. True?
That was my understanding.
Well, tell the ladies and gentlemen of the jury, who were the other two sets of eyes?
I didn't have any specifically, other than Director Maxwell and Mark Penley, I presume, as the two individuals.
And you, did I cut you off?
I'm sorry, we're speaking.
Did I cut you off?
No, sir.
Okay. You anticipated Brandon Kamak providing a report to your office, true?
I did.
And you testified that the Brandon Kamak contract never got to the controller, Michelle Price, true?
That's right. At the time, I don't believe it had.
of course, in this particular situation, it's even a little bit stranger than that, because the jury in this particular context can overrule the judge,
Controller, Michelle Price.
because that's how messed up
That was
this
my
is.
recollection.
But you were wrong about that, weren't you?
I don't know.
Sarah Boone got a new attorney. Oh my God.
Let's bring up Exhibit AG 130. I believe it's already in evidence. If you can find that for me, Mr. Arroyo. Right there. Okay.
Sarah
Could you
Boone
just
is a
highlight the
special
signature
flower.
box for me or zoom in
I
on
can't
signature
believe the
box?
judge let that attorney off the hook.
Michelle Price,
know-
the controller, approved it. Yes?
I see that.
So this contract had the money.
I thought the judge was gonna
Michelle Price
stick it
signed
to the attorney and be like,
Yes, it appears she
come hell or high water, you're the attorney for Sarah Boone.
Told the House Board of Managers
Congratulations.
that she never signed it. True?
She had not signed it before I signed it. That was my testimony, as I recall.
Yeah, at the time you gave your testimony to the House Board of Managers, you didn't know. And now you know, right?
I can't believe the
now
judge
she
let
has
that
signed it.
attorney off the hook.
Leslie French, who's that?
At the time, she was general counsel.
Whatever God that attorney prays
Brandon
to,
Kamak is outside counsel.
you know.
Yes, she initialed this as indicating approval.
I want to talk briefly about grants. Okay? You familiar with applying for federal grants?
Yes, sir.
Okay. Just explain to the ladies and gentlemen of the jury who may not understand the inside baseball of that. Why on earth would the wonderful
Attorney off
state
the
of
hook for
Texas
what?
need to
Sorry.
apply for federal
Sarah
grants for
Boone
related
is
funding?
a woman who's on trial
There
for
are a
murder
number
and
of
has gone
programs that the
through,
office administers.
I don't even know how many
child
attorneys.
support,
Someone said they're on their seventh
victim
now.
services,
But whatever. They've gone through many
supplemented by state
lawyers
funds, state grants,
who keep
as well as
saying,
federal funding.
I want out.
And where does the money come from?
And so this attorney filed, their last attorney filed a motion and said, I want out.
And also federal
And
grants.
so letting them off the hook of being the
Does your office
attorney.
have to apply for them with the federal government?
I believe so. There might be one.
Because
or
the
two
court could have said
instances where
no.
there are statutory grants under the federal statutes, but I think most of them are application.
You know,
And
the
you
court
were
can say
responsible
no.
for
You
applying
know,
for those grants.
Miss Boone doesn't want you to be the attorney anymore.
no, sir.
You don't
The
want to be
grants
the
division
attorney
of the
anymore.
office
But
was
congratulations,
responsible for applying.
you're the
you
attorney.
were overseeing
It's your job.
No,
Deal.
sir. That's a division that reported to Lacey Mays.
Okay. As part of the Office of General Counsel, or by October 2020, what was your title at the agency?
Deputy for legal counsel.
Okay. And so you're giving isn't it true that you gave the Office of the Attorney General
What poor
legal
fool got
advice
stuck
about
with her?
those grants?
Yes.
Okay. I think I'm over the target now.
Fast Eddie says, do I understand that you
So-
can't hear them when I speak? I certainly do.
My understanding is, correct me if I'm wrong, in October 2020, after you had so-called blown the whistle with your friends, you were still providing legal advice to the Office of Attorney General about grant applications to the federal government, yes?
Yes, sir.
And one of the reservations that you expressed was that the Office of the Attorney General might have some problems applying for federal grants because Ken Paxton was under indictment. True?
That was an issue that came to my mind. Yes, sir.
He was under indictment the whole time you worked there, right?
I'm not sure when it occurred, but I believe that's probably true.
In every other year before October of 2020, you didn't provide that advice to the Office of the Attorney General, true?
That's right.
And in fact, if Ken Paxton was not allowed to sign those grant applications, it might have cost the Attorney General's office between $1 and $10 million in federal money, true?
I don't know the specific numbers, but yes, if we were prohibited as an agency from participating in the federal grant program because of an ongoing indictment or conviction for felony that was prohibited under those federal programs, and it could cost the agency.
So after you blew the whistle on September 30th of 2020, your advice about those grants changed, right?
No, sir.
You were advising the Attorney General's office about this all the way on from before that?
No. What you asked is, did my advice change? The answer is no. I didn't provide advice one way or the other that had changed from the previous years.
Okay. Did you advise the Attorney General's office on those grants before October of 2020?
On the specific grants that...
The federal money, that the $1 to $10 million is supposed to be coming to the state of Texas to help the AG's office.
Right.
Did you provide any advice about that before October of 2020?
Not, so just to clarify your question, these grants are typically on a 2-year cycle in most instances. So each time we would consider those a separate grant. So when you ask if I provided advice on these grants, historically, I would have advised on the legal nature of participating in these grant programs at different years.
Did you ever raise your concerns about the Attorney General's being indicted for securities fraud over the last 8 years to anyone before October of 2020?
I don't recall so.
I need to circle back with you and clean something up on the Public Information Act stuff that we talked about yesterday, okay? I want to make sure I have this right, because I think we may have made a mistake, you and I together, or I may have made the mistake and elicited testimony that was not correct. I want to make sure, okay? You remember the 3 requests we talked about yesterday, right?
Yes,
Okay.
The Securities Board, the big request, the FBI brief.
The FBI brief. So on the FBI brief, yesterday I believe I elicited testimony from you that the FBI blew their response deadline, but that wasn't right, was it?
I think is what I testified yesterday is I don't recall exactly what the circumstances were regarding the response deadline or any response that we had requested.
What actually happened is the FBI responded when that unredacted brief was requested, but their arguments were so nonsensical or non-responsive to the issue that your opinions division, which is under your oversight, made the decision to release the unredacted brief. True?
I don't recall what the brief said, the FBI's response to the request for the FBI brief itself. I don't recall what the FBI's position was or what the division issued. Just to put it in context, my youngest was born May 30th of 2020.
Okay.
So I was working out of the office, and at that time, if you recall, the DPS request, the big request, was issued June 2nd. So toward May 30th for the month of June, most of those conversations were directly with Ryan Bangert.
Okay, so is it true that you can't tell, ladies and gentlemen of the jury, why the unredacted brief was released?
The unredacted FBI brief was released because General Paxton directed us to release it.
And tell me about what that process was.
Well, in a meeting with General Paxton, at which Ryan Bangert was attending, we identified that the agency, the Office of the Attorney General, had received a request for public information for the FBI brief. General Paxton asked us to provide him a copy of the redacted brief and the unredacted brief.
Yes?
A few days later, we met again, and General Paxton had reviewed it, had marked up the copies, and indicated to both of us that he had seen nothing that should be withheld from Nate Paul.
Did you disagree with him?
Yes, just based on the content of the information.
Was there any claim of law enforcement privilege made by the FBI?
I'm not advised. Again, I don't recall what their brief said.
You don't recall any of the content of what the FBI said in their challenge?
Not in the challenge, no, sir. I recall the content of the FBI brief that was submitted as part of the DPS file.
Okay.
Okay. I mean, whatever. I don't care.
I'm going to show you a few other documents, okay? We're going to go to stay on the same topic. This is Exhibit AG 185, Your Honor, if I might approach.
You may.
The idea that he wouldn't personally know or personally remember doesn't strike me as particularly odd. He may not have personally dealt with that information, and if he had, I mean, you know, he sees a lot of things. I don't necessarily remember every video I've recorded.
Have you had an opportunity to review Exhibit AG 185?
Or every case I've ever read.
It's a letter dated April 13th, 2020 from the Department of Public Safety to Joseph Larson regarding a public information request referenced as 20-0983.
And Mr. Arroyo, if you'd bring up Exhibit AG 185. Thank you so much.
Pardon me.
Counselor, are you offering this?
I am. I thought I did. I'm sorry. Exhibit AG 185, we move for admission, Mr. President.
Mr. Hardin?
So, I have no objection, but I request that we don't put it up on the easel in the past until we get a ruling, please. Thank you so much.
Agreed.
I agree. Now, Mr. Arroyo, please.
And Mr. Counselor, since we did break for a half hour earlier, that was kind of our 10:30 break, so we'll go to 12, about 40 minutes, and then we'll have lunch from 12 to 1.
Understood, Judge. Thank you. This is a response from DPS to the big request, right?
It appears to be. I don't recall the exact number of the request, but it appears to be.
So Joe Larson is the vehicle that Nate Paul is using to make these requests, yes?
It was my understanding. That's right.
And then the lawsuit that Joe Larson filed, he filed that on behalf of Nate Paul, true?
Well, that lawsuit that you showed me yesterday, it identified Mr. Larson as the plaintiff. I don't know why he would have filed it or what reasons he had.
Ultimately, the unredacted FBI brief was released from a lawyer at the Attorney General's office to a lawyer, Joe Larson, who is working for Nate Paul. True?
I believe so.
No one at the Attorney General's office tried to stop it from going out, did they?
Except for our conversations with General Paxton, I don't think anybody stopped it after he instructed us to release it.
But you didn't have any good legal reason to keep it, did you?
I'm not sure what you mean by legal reason to keep it.
You're a lawyer. Did you have a good legal reason to keep it?
Well, we had reasons to believe that the information contained in the brief itself involved law enforcement information under the Public Information Act, because, as you mentioned yesterday, the FBI redacted it.
But the FBI didn't assert law enforcement privilege over the brief, did it?
Again, I don't recall what their position was in their briefing that they submitted, just because...
You don't know?
That's right.
Okay. Your Honor, I've got another exhibit. May I approach the witness?
Yes, you may.
Have you seen Exhibit AG 253 before?
Yes, sir.
What is it?
This is a...
Hold on. Are you offering this?
I was going to lay the predicate first, but I will certainly offer it.
Excuse me, Your Honor. Thank you. We have no objections if I speed it up.
Exhibit 253, admitted to evidence. Continue.
Thank you. Mr. Arroyo, if you would, Exhibit AG 253. Mr. Vassar, what is it?
This is a.
Do I do much appellate practice? No, I haven't had much experience, Matthew. I'm looking to get into that domain. So if you happen to know of any jobs, Matthew, that focus on appellate practice,
of 2020.
And
I'm
Attorney General
interested,
Ken Paxton issued
because
this
I would like
guidance,
to really
correct?
move into that area, particularly federal,
Yes,
but I'll
he
take
signed
state
it.
as well.
We issued it from the office.
And it is not a formal legal opinion, correct?
No, that's.
Do you have a case you'd like to refer to me as a one-off?
402.
Okay. Did you have kids in a religious school?
I could
at
try
that
to work
time?
on something. Could be fun.
No, sir.
Okay. The purpose of this guidance was what?
To provide guidance on how religious private schools could operate in the face of local orders that may contradict the governor's executive orders at the time.
Pretty important stuff, isn't it?
Yes, sir.
And orders like this were being, orders similar to this that were giving informal legal guidance about COVID matters were coming out of your office almost every day. True?
I'm not sure if it was daily, but we were providing advice on a regular basis.
All right. You recall the quote-unquote midnight opinion. I believe Mr. Hardin referred to it as the midnight opinion, the foreclosure guidance.
I recall it. Yes, sir.
May I approach the witness, Your Honor?
Yes, you may.
That wasn't even the only COVID guidance issued that day, was it?
I don't recall that specifically either.
Ask Barnes. Yeah, maybe I'll drop Barnes an email or something. Barnes and I don't know each other very well, but it's not worth it's worth an email at least.
Of Exhibit AG 7.
Mr. Hardin?
I'm trying to get my microphone on, I'm sorry. We have no objection, Your Honor.
Admit exhibit number 7 into evidence.
Have you seen, no, that's not AG 7, this is 260. Will you put AG 7, please, Mr. Arroyo? Thank you, Eric. Eric, would you zoom in on the letterhead here? This is the letterhead
CPS.
of the Office of the Attorney General of the State of Texas. True?
Family law case.
I wouldn't state that it's the only letterhead of the Office of the Attorney General, just based on my previous testimony.
Well, we'll see how common it is in a minute. This is the letterhead that went out on formal statements, legal guidance, and formal legal opinions. True?
Yes, it was used in those instances.
All right. This Exhibit AG 7 was sent to a man named Brian Mookie, who's of the city of Headwood Village. Do you know where the city of Headwood Village is?
No, sir.
It's in the Houston area, but let's zoom out a little bit. Give me to the text, Eric, if you would. And capture Austin's signature too. I'm sorry, sir. What's this about?
This is the first time I've seen this letter that I can recall. It is issued under Section 418.193, which is the Disaster Act. It appears to be in response to a question that the mayor had asked about local health authorities.
There are no appellate remedies
close
following
schools.
impeachment.
And Austin Kinghorn works for you, true?
It's a
Yes,
political process. There's
And you
nowhere
knew
to
this was
appeal
going
to.
out, right?
No, sir.
Why not?
Just based on the substance, this seems more like a pro forma response that doesn't need to be raised to the deputy level to make a decision.
You can't appeal because you're already in the highest
with
court possible.
advice that we had already
Because it's a
issued.
political court.
And it was essentially
So,
reiterating that advice and not
For the
taking
purposes of the
contrary-
present exercise, they're the Supreme Court
Austin, this
because
was a
they're the
minor
highest
enough
court
issue
because
that
it's
Austin
political.
could do this on his
So there's
own.
nowhere to appeal to.
No. So Austin worked in the general counsel division. That division.
In order to try to
I oversaw
take
that
this
division
into a legal
division of
context, you'd
other
have to
divisions.
show
So I did not have a daily
probably a
the
violation
activities
of
of the
federal law. I'm not even sure hypothetically you could do it in
True.
state law.
Yes, sir.
That'd be rough go.
What's the date on this?
August 1st of 2020.
But if you could show,
Saturday.
I don't know, that the Texas Senate did it as like
I don't recall
a
what
First
day that
Amendment
would have fallen.
retaliation
It's the
reason,
same
maybe.
Saturday
Maybe you could
as
try
the
to
foreclosure
manufacture some
guidance.
sort of federal appeal, but
If that was a
dude,
Saturday, then yes, it would have been.
it
the
would
same
have
day.
to be
Well, you know the foreclosure guidance is dated August 1st,
blatant
right?
I
for the federal
don't
court to even
recall if it's
think
dated
about
August
getting
1. It might
involved.
be August 2nd.
You know? So
Isn't it
I'm going to go with no.
Sir, that there were so many needs in this big state related to guidance about COVID that your office was working on it constantly.
It was a perpetual theme.
Let's see how perpetual it is. May I approach the witness?
Yes, you may.
Thank you.
We move for admission of Exhibit AG 260.
Give Mr. Harden a moment.
I have no objection.
Admit Exhibit 260 into evidence.
Thank you. Mr. Arroyo, if you would. Same letterhead, yes?
Yes, sir. It's the same as the August 1st letter.
July 28, 2020, 3 days earlier, yes?
Yes, sir.
And who's Doug Sveen? Hope I'm saying that right.
This letter indicates he's the mayor of Stephenville, Texas.
He's asking about closure of schools, right?
That's right.
May I approach the witness, Your Honor?
Yes, you may.
I'm going to try to do this in bulk and maybe move this along a little bit.
Look at all my footnotes. Yeah. So yeah, appealing this is a fantasy.
Your Honor, we move for admission of AG Exhibits 259 and 6.
We have no objection, and we have no objection to 289, and we have no objection to Exhibit 6.
Admit Exhibit 6 and 259 into evidence.
Mr. Arroyo, Exhibit 259, please. Who's Craig Morgan?
This letter refers to him as the mayor of Round Rock.
That's on a Thursday before August 1st, right?
Sure.
What's it about?
This is appears to be the city of Round Rock's decision to move its local election from November 3rd of 2020 to May of 2021.
Why do they want to move it?
I think the reason that they had stated was because of COVID.
Who issued the opinion?
It was signed by General Paxton.
Does it have a KP number?
No, sir.
Not a formal legal opinion, true?
No, it was not issued as a formal opinion under 402.
Mr. Arroyo, Exhibit 6, please. AG Exhibit 6. August 3, Monday. Who's the Honorable Vince Ryan?
The Harris County Attorney.
This is a formal legal opinion, yes?
Yes, this is a formal opinion issued under Chapter 402.
Tell the ladies and gentlemen of the jury how they can tell by looking at this document that it's a formal legal opinion.
After the mailing address, there is an opinion number that's referenced. And then in the subject line, there is a request number that's also referenced.
And every formal legal opinion from the Office of the Attorney General under Chapter 402 of the Government Code has both. True?
Yes.
And what's this letter about?
It's regarding the county authority to require masks in courtrooms, courthouses, and county buildings.
Okay, so correct me if I'm wrong. July 28th, July 30th, August 1, August 3. There are opinions coming out almost every day about COVID stuff during this period of time, true?
Well, again, to clarify, a lot of the questions that we would get would follow the governor's executive orders, which were coming out in different points. So if an executive order was issued, the frequency of our requests for advice might increase. I can't testify that we were releasing information daily. I don't know if that's actually true, but I can say it was happening regularly just with the pattern of executive orders or mayoral or county orders.
Isn't it true that the office was constantly adapting to the executive orders of the governor's office, the executive orders of President Donald J. Trump?
Absolutely.
And that actually increased the amount of informal legal advice and the need for it on a literally day-to-day basis.
Well, again, it was very frequent, just given the number of agencies that were involved on a state level as well as the federal level.
Mr. President, a moment, if I may.
Yes?
Oh, I'm sorry. I apologize. I thought you were passing the witness.
No, you ought to keep coming. Pass the witness.
I apologize.
Mr. Hardin, he passed the witness. Just you standing up made it all happen. We'll go to the top of the hour, Mr. Hardin.
Good morning, Mr. Vassar.
Good morning.
I'm going to try to, as best I can, to do this pretty quickly. Thank you so much. We've got several areas here. We can just start where we finished up. I thought I would never have to talk about the different numbers of the different portions of the government code that suggested what y'all should and should not do.
Really?
But I think council's appropriately covered back on the issue, and so I feel compelled to a little bit just try to clear this up just a tad. The two sections of the government code that you folks would have been working over primarily, that you've been testifying to council about on cross, are what numbers in the code?
Chapter 402 of the government code and chapter 418.
All right. Now, let me see if I can do this briefly with you. How do you determine which of those codes apply to a request for an opinion, or the sections of the code, excuse me?
So chapter 402 enables the Attorney General to provide general legal guidance in response to a request from an eligible requester. Chapter 418 is expressly limited to providing advice relating to a disaster declaration, again, to eligible requesters who are different from Chapter 402.
All right. For instance, does which one of those sections apply depend on the identity of the requester that makes the request?
Yes, sir.
And does 418, something that I believe, did you testify earlier, if 418 was amended, the National Disaster Act before COVID, but when COVID came, was frequently used as the basis as to answer a query from a public official?
That's correct. I believe it was amended in 2019. Obviously, COVID hit in 2020, so that provided an avenue for local officials to request legal advice from our office.
Now, if when General Paxton requested y'all to do this hurry-up opinion, if he had come up with a requester that was a mayor, what section of the code would have applied to the opinion that you folks wrote?
Just based on the fact that it was a COVID-related question and that the mayor is an authorized requester, it would have fallen under Chapter 418.
Now, once it was decided that the requester would be a state senator, which section of the code did that mean would cover what you did?
A state senator who is a chair of a legislative committee.
Thank you. Excuse me for interrupting you. That's the caveat. It's not just a state senator, but it has to be a chairman, does it not?
That's right.
All right, resume the answer, please.
A state senator who is a chair of a legislative committee is an authorized requester under Chapter 402.
All right. And is the significance that 402 was applied here is that Section 402 does not distinguish between an informal and a formal opinion, correct?
That's correct. It does not.
Now, if we move forward, that it had gone through if it hadn't been a hurry up and went through your normal processes you testified that would take ordinarily about 6 months, is there a difference in the way the 6-month opinions which are vetted and published in 6 months as opposed to overnight is what we've called this opinion? What would be the difference in the way those two opinions, heavily researched, vetted opinion, overnight opinion, how are those reported to the public and dealt with as far as publishing to the world?
So under Chapter 402, if it's an eligible request, our agency logs it as a request, publishes that request in the Texas Register, which enables third parties who were just interested in submitting their own briefing and arguments to our office. After a drafting period in the division, it's reviewed internally, and including other divisions who might have subject matter expertise on the issue. After all of the division feedback is received, it's circulated to the deputy level and the executive for review and approval. After it is issued, it's then, again, recorded on our website and then published in the Texas Register for public dissemination. And I believe it's also uploaded to Westlaw.
So is one much more widely distributed and easily published to the world than the other?
Yes, sir.
Finally, you were asked about things I think you said you did not know about in terms of the next day or a hearing that you were not involved about, correct?
The hearing.
Very good question. Let me rephrase it. That's a very good question. Do you recall being questioned about what you knew about how the overnight opinion was used on behalf of Mr. Paul?
Yes, I recall that.
You recall you said you were not aware at the time. Do you recall that?
That's right.
All right. Have you become aware, and did you see a document during your examination that showed a lawyer on behalf of Mr. Paul immediately within 36 hours or 24 hours was using that in a court to try to get what he wanted?
Yes, sir. I believe in one of the exhibits that I reviewed, there was a statement indicating that the foreclosure letter that we had issued was used to stop a foreclosure sale related to Nate Paul.
Do you have any idea how one would have known as early as Monday to be prepared to use that in a hearing on Tuesday when you only completed it at 1 o'clock Sunday morning and sent it to the Attorney General sometime Sunday?
Objection, Mr. President, leading and calls for speculation.
Sustained.
Now, let's go to a couple other areas. You recall you were questioned considerably about first of all, the interview that he asked you about a little bit toward the end. And that is that you were not under oath at that hearing.
I recall that, yes, sir.
And I said hearing, I don't mean hearing. It was really an interview by investigators, many are here today, that were retained by the House Management Committee, or the House Committee rather, to do an investigation. You recall that series of events?
Yes, sir.
And I believe you were shown some of the testimony, again, not testimony, some of the interview statement that you gave.
Yes, sir.
Now, did you readily agree to have it videotaped?
Yes, I believe when I sat down, there was a recording that was going to be used for my interview.
Do you remember sort of a sort of fumbling around that nobody had a recorder, they had to go get one?
Yes, sir.
All right. But at any rate, ultimately, when that happened, did you have any objection to it being videotaped and audioed?
No, sir.
Now, did anybody at all suggest placing you under oath?
No, sir.
Do you know enough about law enforcement as to whether or not ordinarily, if somebody's trying to gather information as part of a law enforcement information or investigation, where they would swear to people when they're just trying to get people to tell them what happened?
Your Honor, I have to object to this being argumentative and sidebar.
I withdraw.
Sustained.
Thank you, Judge. Thank you. I'll withdraw the question, but I waited too late. All right. So, if I may, at any rate, you gave that interview, correct? And
Right.
I told him. And that interview was totally available as evidenced by questions you got to the other side, correct?
I believe so, yes. I'm not, yes.
And in that one item that it came up with, there's no suggestion that you've testified any differently today than you did to these investigators, correct?
Objection, leading, and argumentative.
Sustained.
Are you under oath today?
Yes, sir, I am.
Did you testify today the same you did to these House investigators?
Yes, sir.
Can we take that as evidence of the fact nobody's suggesting otherwise?
Object to the argument, Mr. President.
Now,
Sustained.
if I can, you were asked about evidence. Do you recall this? Evidence that you took to the FBI.
Yes, sir, I recall.
And 7 of you went to the FBI, did you not, on the 30th of September 2020?
Yes, sir.
And you took no documents, did you?
That's right. No documents.
Who did you take?
We took ourselves
And you took yourselves to do what?
to provide an explanation of the sequences of events that we had determined
Well, when
revealed information tending to show that General Paxton had abused his office and the powers and responsibility and trust that millions of Texans bestowed upon him to benefit one individual.
And when you went, if you had taken things with you, you would have had to take things that were the property of the Attorney General's office, wouldn't you?
Objection, Your Honor. Calls for
Would-
speculation and a legal conclusion.
Excuse me.
Sustained.
Would you have had any documents other than things that were circulated and created right there in the AG's office?
Objection, Your Honor. Speculation and argument.
I'm really asking him if anything they took would have had to, as evidence, would have had to be property of the Attorney General's office.
Overruled. You may
Thank you.
answer the question.
You can answer that.
But all of the information would have been information that we had obtained just by virtue of our employment at the agency.
Now, when you answered the question, you recall answering the question is you had no evidence that you took to the FBI in that meeting, correct? Do you recall that answer?
Yes, sir, I do.
Well, tell me what you mean by that answer when you say you took no evidence.
Well, the way that I interpreted opposing counsel's question was documents, documentary evidence of what we took to the meeting with the FBI for law enforcement.
After this position, you might want to say, thank God, but you're not a trial lawyer, are you?
No, sir.
Do you have any idea how evidence is defined in terms of law enforcement or people wanting to find out what happened in a situation?
Objection, Your Honor. Calls for speculation. Legal
No,
conclusion.
I'm asking his mind.
argument.
Does he have any idea? That's all I'm asking.
Sustained. Rephrase.
All right. In this particular situation, did you take your body?
Yes, sir.
Did you take your voice?
Yes, sir.
Did you take your brain?
Yes, sir.
Did you take your experience?
Yes, sir.
Did you take your knowledge of the last 9 months?
Yes, sir.
Did you take what things you personally knew of in addition to going with people who may have known other things?
Absolutely.
Did you tell the FBI that?
Every bit of it.
Do you realize in the legal world that is evidence?
Objection leading.
No, that is simply a fact statement. That is not leading, in my
Sustained.
respect. And the court disagrees,
He's not-
which is why we're here.
He's not wrong, though.
ask you
It
this.
is evidence.
If you told all of those people what you knew in your mind,
Testimony is
what
evidence.
you were concerned about,
I'm
what
pretty
is your
sure.
opinion now, after the primer we just did, as to whether you gave the FBI evidence?
Object leading. Argumentative. This is closing statement, not a question for the witness.
I've asked him what his opinion, excuse me, Your Honor, I asked him what his opinion is. I didn't ask him.
Overruled.
Thank you.
My opinion was that our experiences were evidence, but we did not conduct our own investigation to provide documentary evidence of what we had come to learn.
Well, what did you provide him?
Just our experiences.
What do you mean?
The situations in which General Paxton asked us to act involving Nick Paul, the cumulative knowledge of the conversations that we had as a group between September 29th and the morning of September 30th, once the grand jury subpoenas for Brandon Kamek started coming to the office.
Whose job then, in your opinion, was it then to conduct the investigation?
Federal law enforcement.
Did you ever view yourself as an investigator in this matter?
No, sir.
What did you think you were when you went to the FBI?
We were
Witness.
witnesses.
Pardon me?
I believe that I was a witness to criminal activity that had occurred by General Paxton.
Do you know of any other occasion in which the Attorney General involved himself in the drafting of an opinion such as what you did in August on the issue of foreclosures?
I can't think of any. No, sir.
Finally, maybe from your age you don't know this. Are you familiar with the movie Cool Hand Luke?
I've heard of it. I'm not familiar with it.
You ever see the scene in a very, very bad moment in the movie, for at least a bad moment for Paul Newman,
What are
in
we
which
doing
the
right
bad
now?
guy stands over there as he's digging and says, what we have here
I'm gonna
is
object
a
to the
failure.
argument.
Let me just finish. A failure to communicate. That's just the question.
Overruled.
Objection, relevance, stupid.
Thank you. Have you?
I've not.
All right. Let's talk about these supposed altered documents. All right? You tried several times, did you not, on your cross to explain?
Is stupid a valid objection?
types of
And if not,
letterhead
can we make it
referred
one?
to the AG's office. Do you recall telling him that?
Yes, sir.
You recall he went right by. He didn't want to deal with that, did he?
That's right.
All right, well, let's deal with it real quickly. For instance, in the Attorney General's office, did y'all periodically use one type of paper that did not have General Paxton's on it and another type of paper that did?
Yes, sir.
Do you have any idea how the circumstances were that dictated which you would use?
No, sir.
All right. On the occasion when the letter that we've been talking about, that they have been complaining was altered and the Attorney General's name was taken off, was that letter complaining about the Attorney General?
Yes, sir, it was.
Well, if you're writing a letter complaining about the Attorney General, what is your opinion as whether you would want to make sure his name wasn't on there for a letter complaining about him?
Objection leading.
Sustained.
Let me ask you this.
Have you ever seen the movie Pirates of the Caribbean, Curse of the Black Pearl? Do you remember the scene when Captain Barbossa said, "I'm disinclined to acquiesce"?
I'm going to show you
Is that representative of you?
letter that is already in evidence, Exhibit 127. May I have it on the screen, please? Is that an altered letter?
Counselor, excuse me, we don't show that being already entered.
You do not show it.
Do you remember when Captain Barbosa said the Pirates Code was more a set of guidelines? Is that how the Attorney General's office treated his own internal policies?
No, not at all. I misled you by making you think which one it was. We were both inadvertent. But I think it is interesting to point. Would you look down to the bottom? Would you circulate where the exhibit and whose exhibit this is? And let's sort of, if we can, highlight, Stacy, both from whom the production was that produced it to us. OAG stands for what?
The Office of the Attorney General.
And are you familiar enough?
Note to self for the future.
Process,
movies are now considered precedent I can cite in court.
That appears to be a reference to an exhibit that the Attorney General's defense team has offered.
Do you have any legal authority for this proposition, Counselor?
We can. Would you expect?
Well, Your Honor, in not another teen movie. ...
All right. Well, in this offer, is the Attorney General's name on it?
His name is not on the seal at the top of the document.
Is this seal identical to the seal that y'all used for the letter you wrote before you went to the FBI?
Yes, sir, it is.
Or after you came back? I can't remember what. I don't want to misstate when it was.
It was drafted and reported or sent to HR after we returned from meeting with law enforcement.
All right. So it would have been on the 20th when you came back on the 30th.
30th.
When you came back on the 30th. Thank you. All right, now, let's go to the next to last page, I believe, of this exhibit. Do you see who it's signed by?
It's signed by Jeff Petier.
Now, Stacy, just to test your agility, will you go back to the front page again and isolate the date this was?
I like it. We can do law by memes. It'll be great.
That date is October 1st of 2020.
All right.
And then it'll be like that one Star Trek episode where the aliens are just communicating in memes.
Not been introduced.
Shadrach, when the walls fell.
Tender. Do we have copies of our exhibit 633?
Your Honor, Cool Hand Luke, rebuttal, The Matrix. Damn it. He's got me.
I'm going to move to introduce. I was waiting for you to review it.
Oh, thank you. No objection, Judge.
Admit Exhibit 633 into evidence.
Can you put it up on the screen, please? Thank you.
Although, to be fair, I suppose, in the broader context of this trial, it's at least as reasonable a question as have you ever heard the phrase, there are no coincidences in Austin?
Have been in
So,
with any particular
I suppose there's that, to give all
anything
credit
about
to
this?
the person asking the question.
I don't recall exactly.
As long as we're doing
if
sayings and musings, you know,
involved
Cool Hand
reviewing
Luke is
it.
as valid as
Again,
anything else, I guess.
I was appointed Deputy AG for Legal Counsel April 1st of 2020. It's possible I reviewed it, excuse me, in the General Counsel Division, but I have not seen it since.
And the letter is signed by whom?
It's signed by General Paxton.
Now, we
And
can assume, can we not, that General Paxton didn't alter this letter?
I wouldn't presume so.
And is it also similar to the letter y'all sent on paper that has just the seal?
That's the same seal, yes, sir.
So let's once again make sure there's no misunderstanding. Or do you understand for the last 4 days you folks have been accused of altering a document?
This is a violation of the rule,
Excuse
Mr.
me.
President.
Let me put it another way. I'll put it another way, Your Honor.
Was there an objection?
Objection, violates the rule.
Sustained?
If anybody was to suggest that you guys had, when you wrote your letter, that you had somehow altered it and taken the Attorney General's name off and therefore altered a government document, would that be true or not true?
That's not true.
Would it actually be a lie?
As these documents indicate, there are different seals for different purposes. And in this situation, we used the seal without General Paxton's name on it. That's the seal that was...
You are indeed, are you not, Mr. Vassar, a kind and gentle person.
Oh my God.
So much so that even after enduring yelling and constant interruption, you still don't like to use the word lie, do you?
Oh my God.
No further questions.
Objection sustained.
Isn't it true that you're an honest
Do you intend to
and
withdraw?
forthright
I do,
and
Mr.
truthful
President,
and
but I can
wonderful
probably resolve it in
person?
about 3 minutes.
I'll give you 3 minutes.
Thank you, Judge.
In 5 at the most. There you go.
I will try to yield some back, Mr. President. So it's okay to give your personal lawyer documents from inside the Office of the Attorney General, but not the FBI, right?
I provided documents under a grand jury subpoena that I received to my lawyer, so I don't know what the implication is.
You had internal OAG documents, to wit, a series of grand jury subpoenas that were served by Brandon Kamak that you sent to your personal lawyer, but you didn't bring any documents to the FBI, right?
That's absolutely true.
And you went to the FBI, David Maxwell went to Travis County, they investigated, and they still have done nothing, true?
I don't know what they found. I know it's an ongoing investigation.
Mr. Hardin talked to you about the letter that Nate Paul wrote to the court about the OAG foreclosure guidance. Do you recall that testimony, those questions?
Yes.
All right, Your Honor, Mr. President, I have one copy of AG Exhibit 286. If I may, I will tender it to Mr. Hardin for his review, and then to Your Honor, and then to Mr. Vassar.
You may.
I didn't know you could do that. I didn't know you could just ask the witness, isn't it true that you're loving and kind and wonderful and brilliant and everyone loves you and you're popular at parties? I didn't know you could do that. I'm learning all kinds of fun trial tactics today. See, this is why we like this channel, because we all learn something. We learned that apparently you can just ask the witness, isn't it true that you're great and wonderful and everyone loves you and
I have no objection.
What is the
birds
number of
come
that?
to you and land on your hand
Mr.
and
President, is AG
sing
Exhibit
songs of
286, and we
peace?
move for its admission?
The Exhibit 286 will be admitted into evidence.
Mr. Arroyo, if you could assist us, please, very briefly. Mr. Vassar, who's Stephen Benish?
I have no idea.
You should know him. He's your state bar president-elect. This is a letter from Stephen Benish, who was opposing counsel to Nate Paul in the WC 4th and Colorado matter. And he wrote a letter. Mr. Arroyo, please blow up the text of his letter.
I'm not sure why.
Mr. Benish says in response to Nate Paul's letter, like lawyers often do, I disagree. And he wrote to the judge and he said, the foreclosure sale isn't being stopped by this OAG informal guidance, right?
I've never seen this before, but I see where he says the AG's, quote, informal guidance does not emphasize, state that foreclosure sales may not proceed unless specifically authorized by the mayor in the city of the foreclosure.
And what happens in courts is one side makes an argument and the other side makes an argument and the judge decides, right?
Yes, sir.
Only in this case, Nate Paul put his entity in bankruptcy to stop the foreclosure, right?
I'm not sure.
That will be all, Mr. President.
Thank you, Counselor. We will break until 1 p.m.
All right. Well, we're also going to take a break here, obviously. So I'll just summarize. And also, I need to schedule for this afternoon. So we will come back at 12:55, and I'll go grab some lunch, obviously, in between. But while I'm scheduling, I'll talk as well. So overall, today's cross was not as dynamite as yesterday, because yesterday was pretty great. Although it was more about destroying, like, him as a person, or destroying him as a, it was more viscerally satisfying than maybe legally operative. But it was very good. It was very good. It's like you attack, you attack where you can, and they attacked where they could, and it was very effective as they could. It was a little bit of a distraction, but still viscerally satisfying. So I enjoyed it. Today was...
Could I have one of the House managers come up and one from the defense come up just to clarify if the witness has been excused? I wanted to be sure there was not a redirect. Okay.
There shouldn't be a redirect. If there is a redirect, I'm going to be very sad. We'll say 12:50 p.m. for this afternoon. Anyways, what I was saying was more viscerally satisfying than perhaps ultimately legally operative. But that's okay. But there is some stuff here. There's definitely some stuff being done that might show why Paxton was doing things the way he was. COVID changed the operations of the office, as you would expect. It's a major external pressure that's going to kind of, disrupt things. And so Paxton might have to do things abnormally because the situation's abnormal. So that was, sort of teasing out the ideas. Some things that were not particularly effective, though, like there was this part where he was saying, well, isn't it true that you guys have however many cases they have pending, whatever the number is, and isn't it basically true that that Mr. Paul is a very small number of those cases, and you have 800 attorneys and only like maybe 15 attorneys touch this, and isn't it true that Mr. Paul is a very small number of those cases? But that doesn't really do anything. That doesn't really do anything, because that kind of speaks to remedy more than liability, right? If Mr. Paxton, for the benefit of Mr. Paul, out of corrupt motive, assigned one attorney out of the 800 to help Mr. Paul in one case out of the tens of thousands the AG's office did, it would still be corruption. Now, I suppose at that point we could decide how much we care, but the scope, the gravity of the corruption doesn't necessarily change the fact it's corrupt. So that part wasn't particularly effective, right? Is it true that it's only 10 to 15 to 20 attorneys? Is it true that it's only a couple of cases? Maybe, but I don't really care. Because if Mr. Paxton did it out of corrupt purpose and corrupt motive, I'm not sure it really matters. You know, if you break the law a little or break the law a lot, you're still a lawbreaker. So, it was not particularly effective in that respect. And also just like, some other things that were kind of a little bit mealy, unimportant, tangential, and other stuff too. So but I think what can be said for the defense is that they've laid out the groundwork for the idea that, there might have been other reasons other than their perceptions. And I think that will go more of the defense's case, but they're laying the groundwork for that now, which is fine. And also just, tearing the witnesses apart a little, which is viscerally satisfying. So we'll see. Yeah. Oh, Sandy sent gifts. That's good. Yeah. So let's take a look at some gifts that were sent by you today, which are always appreciated, by the way. We appreciate everyone who helps to support the channel financially. Tony P. gifted 5 gift memberships. Sarah Silverman gifted 10 gift memberships. Kate Lee asked, what's the best way to get in touch with me? Email works. Kurt at Uncivil Law LLC. That's KURT at Uncivil Law LLC. JL became a $19.99 uncivilian. So gifting $20 a month. Donating at that high tier. Thank you, JL, for your kind contribution. $20 a month. That's very, very nice. Brian Gibson has been a member for 10 months. Jules Buddha gifted 20 gift memberships. As always, Jules Buddha, a strong supporter of the channel. We do appreciate your constant contributions. Thank you very much. Springstorm gifted 20 gift memberships. Baby Meatball's been a member for 11 months. E.L. Warner's been a member for 11 months. Keith L. says, next time you read the book of the Holy Chosen One, is there a way to play classical music in the background? I don't know that we should, because the words are so great. Why would we want to have any distraction in the background? The classical music would do nothing but pollute from the glory that is the text. So I think for that reason, we should not do that. And we do appreciate everyone who supports the channel, as always. I think the evidence supports the proposition that that there was something rotten, at least the perception of something rotten in the state of Denmark. And there's that. So I think there's some evidence to lead to the conclusion that Paxton was doing improper things for improper reasons. So let me give you the link for this afternoon's session as I spam my own chat. There is the new link for the new Twitter for this afternoon. So if you could make sure to retweet that, that would be appreciated. And I will see you in about 40 minutes-ish. Until then, my friends, I've been Uncivil Law. I hope all is well, as always. Cheers, my friends, and for now, goodbye.